stops, everyone please find a seat. La da 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 da. I open the hearing of the Children and Family Law Committee on Tuesday, January 28th, 2025. First up is House Bill 322, allowing a parent paying child support to retain the exclusive right to claim the child as a dependent on, it should be his or her, tax return. And the speaker calls up Representative Barton, who is the prime sponsor. Not yet. There we go.
Thank you, Mr. Chairman.
Welcome. You may begin.
Thank you. So I submitted this piece of legislation. Some of you may or may not know that in 2018, since 2018, child support payments are no longer tax deductible. So you can't claim child support on your as a tax exemption. You still have to pay taxes on all the child support you would pay to the other spouse, from one spouse to another. And it doesn't count as income for the person receiving. So it's technically it's support for the child, but it doesn't count as income. And it seems an injustice since 2018, since the payer can't take the exemption. They ought to at least take the child tax credit, as they're the primary financial supporter of the child. So they should have the exclusive right to claim the child if they are providing financial support exclusively. That's all I had to say on this bill. I'm happy to take any questions or provide any rebuttal.
Questions, Representative Gregg.
Thank you, Mr. Chairman, and thank you for being here, Representative, and for taking my question. So my question is, we do know within child support that sometimes people are paying child support, and it might even be like $50 a month. So they are not the prime, financial supporter of the child. So in that case, why would they be able to claim them on their taxes if the other person is providing more?
I'm not sure how you could say that they're not the prime supporter. Even if they were paying $1, that would be $1 from one spouse to the other. Why isn't the other spouse paying anything? They're the primary supporter because they're paying to the other spouse. Either they're making more money, the court determined that they make more money. I think what would happen as a result of the passage of this legislation is if it was determined that the disparity or the $2,000 tax credit would essentially be a wash, or that it would be a benefit to one party or the other, they should just not have child support, and there would be no child support payment, and they could alternate tax years for the exemption, which would be much more valuable to either spouse. So the $50 argument, I think, is pretty moot.
Representative Gregg for the follow-up.
I appreciate your opinion on that. My question is, though, how much does it take to provide for a child? Like if somebody's supplying $50 a month, how much do you think it actually takes to provide for the child, and where the rest of that money coming from?
Thank you for that question. So in the state of New Hampshire, I guess some children are more valuable than others based on child support payment. It's all about the income of the parents of the child. That's how it's decided. So if the parents are providing equal financial support to the child, it would be essentially a wash. But if one parent is paying $166.67 per month, that would equate to $2,000 a year. So maybe that's the threshold at which the parties get together and say, it's a wash, we might as well just alternate the tax credit instead of one person having to pay taxes on top of that $166 a month, whatever that minimum is, because they're punished by having to pay the taxes on top of it. It's free money for the person that's receiving it. So why wouldn't they get the tax exemption?
Representative Raymond.
Thank you. I want to follow up on what you just said about paying taxes on it, because I'm confused how one pays taxes on child support.
Yeah, I'm happy to explain that. So how you pay taxes is, in order to pay money to the other party, you have to first earn it. And when you earn that money, you pay income taxes to the federal government on that money that you earn. So you pay the taxes first, and then you give the tax-free money to the recipient. That's how.
Do you know what the New Hampshire...
Follow up, Representative?
Thank you, Mr. Chairman. I apologize.
That's okay.
Do you know what the New Hampshire Fiscal Policy Institute has estimated the annual costs are for things like childcare or rent in New Hampshire?
I don't, and I think it's completely irrelevant to this case. It's all about if one parent is paying money to another, they have to pay taxes on it. They can't get a tax exemption anymore, so they ought to be able to claim the child as a dependent on their tax form, like they could before 2018.
Representative, any further?
Just one last one.
Go ahead.
Would it surprise you to know that the average cost of childcare is almost $20,000 a year in New Hampshire, and the average cost of a two-bedroom apartment is $1,900 a month?
No, it wouldn't.
Thank you.
Representative Corzine.
Thank you, Mr. Chairman, and thank you for being here to answer our questions. In regards to if one party pays the other spouse $1, doesn't the custodial parent pay for that child and everything that the other spouse is not paying for? I mean, if you have a husband who's paying $1 in child support, wouldn't the parent that is taking care of the rent and the bills and everything else be paying a lot more than that $1?
I think that would be determined by the court. I mean, the court would determine, who has to pay what. But if they're not each parent, and I believe we're a 50-50 state, or at least we promote that. But each parent would provide essentially equal care for that child. They have an equal burden, and whether it's the father or the mother who's the primary financial provider, they still have to pay taxes to whatever they're owed or whatever is ordered, and whether they have primary custody or secondary or a lower arrangement, it shouldn't matter because they're the primary financial. And it's $2,000 that we're talking about. It's not $20,000. It's not $30,000. That burden is shared. It's the taxes that are paid on the child support that since 2018 there's an imbalance on. And so, if the amount was $166 a month, it would be a wash. I can tell you it's probably 10 times that for a lot of cases. So $2,000 is very small than a tax exemption you would have received before 2018. So a lot of the arguments here are moot.
Follow up. Thank you.
The custodial parent is going to be putting in the rest of that amount to raise that child. Regardless of the court's decision of whether somebody has to pay $50, the custodial parent then is paying a lot more. So to automatically give the first spouse the tax exemption just seems wrong.
Is there a question?
Yeah.
Make sure it's a question.
Sorry.
That was a question. Okay, next time.
Would you believe? Sorry.
So to comment on that, if you're saying one parent pays more than the other, they should be providing equal support from the family courts. I don't know how you can say one parent is paying more than the other just sporadically like that. in many cases, there is an inequality, but the court should say you have this burden and you have this burden, and it ought to be balanced fairly, whether it's the time with the child, the amount of care that's given from one custodial parent to the other. But at the end of the day, when it comes to finances, it used to be the person paying the child support could declare it as an exemption, and probably thousands and thousands of dollars, declare it as an exemption, and they would alternate years, or they would come up to some arrangement with declaring the child as a tax credit, which is really small dollars, maximum $2,000 for a kid. So it seems only reasonable once you pass a certain threshold of child support that that the financial provider should be able to, at least recuperate some of the money that he's already paid taxes on, or her has already paid taxes on.
Anyone who hasn't asked a question yet? Representative Nelson?
Thank you, Mr.
Welcome.
Speaker.
No, actually.
I'm so sorry, Mr. Chairman. Sorry.
You got a promotion.
I promoted. Sorry about that. I'm sorry about
Don't
that. Thank
do
you for
this to
taking my
me.
question. My husband paid child support for a very long time, and his ended well before 2018. But just for my curiosity and reference, do you know what? How do I find out about researching that? Because I don't recall us ever taking a deduction on our taxes when we were married and filing together.
It should have been in the decree and part of the either the parenting plan. So one of the three it's the universal support order. It would be in the universal support order, who gets to claim the child on what year.
Follow up, please.
Follow up, yes.
So I'm confused. I'm sorry. I'm just trying to sort through this. I'm confused because taking a tax credit versus taking a deduction for the amount of money that you paid in child support are different. So I'm confused about what you're saying, actually.
Is there a question?
Yes. Could you please clarify whether you're talking about a tax credit or a deduction for the total amount that you paid in child support per year?
Yes. So tax deductions, as I said before, do not exist anymore since 2018. So there's no such thing as a tax deduction for a child for child support. You can only get a child tax credit. That's it.
Okay. Thank you.
Sorry.
Representative Raymond?
I'm sorry, Representative George has had her hand up as well. She hasn't
Sorry,
spoken.
I didn't see that. Representative George?
Thank you, Mr. Chairman. I just want to know, because I know there is a lot of parents, sometimes the woman, the one who's in the custody, take care of the kids, okay? And you know how much for someone who take care of, can be 2 child, 3 child, yourself. Do you know how much that person is making for take care of all those kids? If the one pay child support to just give $40 or $50 a month, how much the person who are take care of the kids, you know how much is cost for her?
Well, I mean, if I, as a man, was taking care of my child and I was receiving child support, you're asking how much my taking care of my child is worth?
Than the $50.
Then
Because when you take care of the kids.
I'm sure the courts would determine that based on the financial affidavits of the two parties, and that it's not the same for every person. Like I said earlier, children in our state have different value. Some children are worth more than others. Yeah, I know it's crazy, but otherwise there would be universal child support, and it would be this child is worth $20,000 a year, and and that's it. So if you have one parent that makes $2 million, their duty of support, at least that's what I'm hearing from the committee, would be not based on the income of the parents in their financial affidavit, but that base support, that monetary support of $20,000, I guess, is what I heard. Why isn't it based on that? It's not. It's based on the income of the parents. And the disparity of income between the parents is how it's calculated. And now I'm not here to debate how a family court judge determines how much is owed in support by looking at the burden on one party who's taking care of a child. I would say in cases where there's 50-50, which is a majority of cases, both parents would share that burden equally. So why does it matter? I don't know. But I'm simply here to say the person that's the primary financial support provider should, at the very minimum, because they're paying taxes on the money to the recipient who is not paying taxes on the money that's being received, ought to at least claim the small, tiny benefit of the child tax credit, which is maximum $2,000.
See one hand up, Representative Malone.
Thank you. So can we go back to definitions? Because you are saying somebody that pays child support versus main financial provider. So someone can pay child support and not be the main financial provider. So that's where I'm getting confused, because I felt like that's what family court would do. Whoever pays the most, they would get to claim that child. That's how I've seen it in the past. But just because you pay child support, and I think maybe this is clearing up, does not mean that you are the main financial supporter of that child. So is it just because you pay child support, or is it because you pay more than 50% of that child's income?
I would think that if you weren't the primary financial provider, you wouldn't be paying any child support. In fact, I don't understand the specific scenario that you're talking about. But if a court orders, it should be equal between the parties based on whatever the order is. Even if it's not 50-50, one party paying the other party still has to pay taxes on that money, and the recipient doesn't have to pay taxes. So, I mean, if I was able to change the legislation and make it so that you had to pay, the recipient had to pay the taxes on the child support, that would be something different. But the dynamics of the law doesn't work that way. So this is all this seeks to do is correct what was changed in 2018. In 2018, the IRS was tired of chasing deadbeat parents who were claiming the exemption but weren't actually paying the child support. So that's why the IRS changed its statutes. It penalized everybody that pays child support because they can't claim the exemption anymore because there's a bunch of deadbeat parents out there, and it's not fair. So this seeks to at least remedy that.
Since we seem to be asking now the same questions, I want to thank the representative for presenting his bill, because I have another pink card before me.
Okay, and I'm happy to stick around for rebuttals.
And the chair recognizes Mary Kruger from New Hampshire Legal Assistance. And you have written testimony. And
Thank you,
skill
Mr.
at turning
Chairman.
the
I
mic
did
on. Thank you.
distribute the written testimony, so I think everyone has it now.
No, we do not.
I handed it to Representative Malone.
And that's where it's going. We do not have it yet. We soon will have it yet.
Terrific. Got stuck.
The chair recognizes Representative Grossman for passing things to her left.
There was a red light. It was just a red light.
Oh, did she think the red light meant stop?
Did. That's what I thought.
Oh,
Thank you.
So I'll begin while people are passing, if that's okay. All right, just move it along.
Yep. Gotta do
My name is Mary Kruger. I am an attorney with New Hampshire Legal Assistance. We are a statewide nonprofit law firm. We represent low-income and aging clients throughout New Hampshire in civil legal cases. So we do what's commonly known as legal aid or poverty law. And we're very concerned. We are opposed to the passage of HB 322, especially for the low-income population. This could really cause issues for people. Often the people that we represent in family law cases, we exclusively do domestic violence cases, and we represent victims and survivors in high lethality domestic violence cases. But often both of the parties are living at or below the poverty level. And so courts right now can adjust accordingly who gets to, how the parties share, who gets to claim children as tax dependents. And I understand under this particular bill, if the parties agree to do it a certain way, they can still do that. We often have cases where parties, they may actually agree on that, but they don't agree maybe on a lot of other things. So they may be both proposing to the court that they share, often splitting children in a particular way to be fair in different tax years. But the court is making that decision and making that order. If it is in dispute, the court would not have the ability to fairly determine, especially in cases where you have like a $50 a month child support order, which, can be common. It can often be a fairly low amount. And so this is a way to sort of compensate for parents to be able to afford basic needs for their children. And so having this be a mandatory requirement would really remove the ability for courts to fairly allocate the resources, which are often limited in the cases that we handle. And so we are asking this committee to vote no to the passage of this bill.
Thank you, Counselor. Any questions? Representative Raymond.
Thank you, Mr. Chairman, and thank you for being here. I'm actually really glad that you're here because my question is about court and judges. So I'm a child of divorce, as many people in my generation are, and my parents switched off year to year on who got to claim myself and my sisters. Are judges doing that now, like making orders saying you get it this year, you get it that year? Are they able to split up kids where maybe someone has this child more and another child less because of the child's needs? Do judges currently make distinctions like that?
Yes, all the time.
Okay.
It's very common for judges to do that. And then they'll account for, like, if there's 3 children, they'll account for kind of switching the third child around. And then they account for what happens when they are no longer, they age out of being a tax dependent, depending on when that happens. They'll write that into the decree.
All right, follow up.
Follow up, yes.
If a family situation changes, so say one person has been paying child support, but he or she has a financial change in their life, like they've lost their job or whatever. Can people go back to court and have judges change currently who is doing the tax credit or whatever the orders are?
People can go back to court on a child support case every 3 years by law, or when there's a substantial change in circumstance, and they would be able to request a change to who claims tax dependence within that request to change the child support order.
Okay, thank you.
Any additional questions? Seeing none, thank you for your testimony.
Thank you.
This ends the hearing on House Bill 322. What do you think? I open the executive session now on this bill, and the chair calls on Representative Rice for a motion. 322. That's all right.
Thank you, Mr. Chairman. I would like to make the motion of ITL on House Bill 322.
And looking for a second, Representative Gregg. Thank you. Any discussion among the committee? Representative DeSimone.
Thank you, Mr. Chairman. As a co-sponsor to this bill, I co-sponsored the bill because I thought it might bring some relevance to the to increasing the child support RSAs that would better what we currently have. I thought it would strengthen our child support in some way, manner, or form by listening to the testimony of the sponsor. However, in my opinion, this bill not only does not accomplish that, but it in fact decreases the value of our current system. And for that reason, I have to support the ITL motion 100%.
Other members of the committee wish to speak on this. Representative Levesque. Not pronouncing all the letters.
Yes. So I have many family members that have stayed together, gone through divorce and everything, and some of them actually they would switch every other year when who would file the kid and when, and each situation was different. And I think that the court system and the parents can decide what's best for their situation and what's best for them based on like financially and who's more the stable parent, who's not, and determine it that way, that the courts have been doing in the past. And I think that that has been working so far. If there is an issue, I think that the courts would come to us and tell us this isn't working like they've had before in situations.
Thank you for your testimony. Anyone else? Representative Love.
Our child support laws certainly need work. I think the judicial discretion parts of our laws are way too strong, but this bill isn't it. I'll be supporting the ITL.
Thank you. Anyone else? Representative Georges.
Thank
Didn't
you,
have to
Chairman.
look.
Thank you, Mr. Chairman. My testimony is like I'm here as a cultural person too, to show like there is some parents who are not. Sometimes they are here, sometimes they go back to their country or what, but they don't. They're gonna say they don't working, or they come here, they work just a little bit, but where they go over there, they work, they do a lot of work, they make money, but they don't give it to the kids. They don't give it to the wife. And I think so if we support this, that to say like give them for the independent, I think so that to give them again more money. And I think so that is my testimony.
The motion before us on House Bill 322 is inexpedient to legislate, moved by Representative Rice and seconded by Representative Gregg. Would the clerk please call the roll?
First.
Yes, and just to let everybody know, a yes vote is to the motion ITL. Okay, yes.
Yes.
Microphone on, please.
Representative Rice,
Yes.
Representative McMahon,
Yes.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love,
Yes.
Representative Corzine is yes. Representative Markle,
Yes.
Representative Pellegrino,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond,
Yes.
Representative Georges,
Yes.
and Representative Malone.
Yes.
This is where Representative Gregg has a question for the chair.
Is this going to go on consent?
Would you like it to go on consent? You've all consented. Thank you. So this is on consent, and Representative Rice, before the end of the day, would you please get your report? It goes first to me, then to the clerks, and then wherever things go. Thank you. This ends the executive session on House Bill 322. Next up is House Bill 325. We welcome back Representative Barton, and the bill is eliminating term and reimbursement alimony and divorces granted on the grounds of irreconcilable differences. And looks like we have written testimony.
Thank you, Mr. Chairman. What's being passed around is the 13th Amendment of the United States Constitution. Many of you should be familiar with it. We all have oaths to uphold the Constitution, and I take mine seriously. The 13th Amendment of the U.S. Constitution abolished slavery and involuntary servitude. What's alimony? Alimony is the service, the financial service of one party to another after a marriage contract, after the contract has been completely dissolved. It's basically a court saying the contract between these two parties, specifically in irreconcilable differences cases or no-fault cases, that the contract between the parties that made it so one spouse had a duty to the other spouse and vice versa, that contract is null and void. But no, you still have to keep this provision. It's gonna survive the dissolution of that marriage contract. I'm gonna make you, spouse A, a slave to spouse B indefinitely. You're going to have to work and pay money, even though you don't owe a duty of support to the other spouse anymore because the marriage is dissolved. So that's essentially what alimony is. And it ought to be dissolved when the parties seek to have the agreement that they made dissolved. This is limited to no-fault divorces and irreconcilable differences. It's not restricted as in for-fault cases as a remedy to make one spouse whole over the other. I don't want to go down that road at all. I think in those cases there should be discretion. But in cases where the marriage contract is dissolved by both parties, there's absolutely no way that one party should continue a marital obligation to the other. Can you imagine if you don't have marital relations, it's grounds for divorce in our state. But can you imagine a judge ordering post-divorce decree one party to provide marital relations to the other party? It's absurd. Why should any provision of a marital contract survive the dissolution of that contract? And why would that not constitute involuntary servitude as described in the 13th Amendment? I'll take your questions.
Any questions for the representative? Representative Rice.
Thank you very much, Mr. Chairman. Thank you for taking my question. Would you believe that if a spouse supported one spouse all the way through medical school, through getting their license, establishing a successful practice at the expense of them getting a degree somewhere, staying home, raising the children, etc., do you not believe they are owed for the sacrifices they themselves have made?
I believe that the agreements that are made between, I wouldn't want to get into the agreements between a party. If that's not part of a marriage contract or You know, if a spouse wants to voluntarily provide something to another spouse, you know, that would be like a division of assets thing, or you would look at the debt, I guess, as far as that division. There's no duty of support from one spouse to another when the contract is dissolved, regardless of who put who through medical school.
Would you believe that that's one of the main purposes of alimony?
Again, no, I wouldn't believe that, and I would think that it's irrelevant.
Seeing no further questions, thank you, Representative. And I'm searching for a pink card that would accompany a handout. Do you pass a pink card down?
No, yeah, this is for the next bill.
It came with the papers.
It did. Did you have the pink card?
Oh, wait, I might have it here. There we go. Yep, I've got it.
All right, so nobody cries. We're all going to take turns being the roadblock, so no one's feeling it. You're next.
Representative Love's red light is on. That's the problem.
That's
I
what it
understand the
is. No, you have another duty, Representative Gregg, is to remind me of things. The chair recognizes Attorney Mary Kruger. By the way, when I call somebody representative, it's not necessarily an insult.
I won't take it that way. Thank you, Mr. Chairman, and thank you, members of the committee. My name is Mary Kruger. I'm an attorney with New Hampshire Legal Assistance. We are a statewide nonprofit law firm, and we represent low-income clients and aging clients in civil legal cases across New Hampshire. We also operate our domestic violence advocacy project, where we represent victims and survivors in family court getting protection orders and in divorce and parenting cases. We oppose HB 325 and ask the committee to also vote inexpedient to legislate. There are three main reasons. One is that we believe this would harm domestic violence survivors, especially because financial abuse and control is present in as many as 99% of domestic violence relationships. I did attach to my handout a fact sheet about financial abuse, which is something that's often overlooked. When we think about domestic abuse, we often think about the physical violence, which is also, can be extreme and concerning. But the financial abuse can often keep a victim in a relationship because they don't see a way to be able to afford to live, especially when there's children involved. And the second reason is we believe that this could increase the level of adversarial divorces in New Hampshire. And then our third reason is that this will harm especially older spouses who've sacrificed careers in order to stay home and care for the family. And that's an agreement that often people will reach. And if they get divorced later in life, they may not have been out earning income, paid income. They've done a lot of work that's worth something. And that's the reason why we have alimony. And we worked really hard in this committee, I guess it was about 2018, to revise and update the alimony law in order to have more predictability in the way that courts can determine not only whether alimony should be paid, or but also how much and for how long, so that it's going to reduce the level of adversarial proceedings in our court system, so that people are more likely to come to the table and make agreements. What this would do is not only make it harder for domestic violence survivors to leave knowing that the financial control can continue. And if they seek a divorce, or the other party seeks a divorce based on irreconcilable differences or no fault, they're not entitled to request alimony if this law would be passed. So they would have to plead fault grounds. They may have a basis for that, but fault grounds are extremely grueling to prove, and it costs a lot of money. You're going to be helping finance attorneys with this bill because people will have to, if they need alimony, figure out how to bring their fault case and prove it. And it's a high bar. I can tell you that in the work that we do, we don't have a lot of cases where we have high earners on the other side because we're representing low-income people, but every now and then we'll have a very extreme financial abuse type situation where there's a high earner on the other side. We may not opt to do fault grounds because of the traumatic situation that this can cause for somebody to have to go through a fault case. It's not good for anybody involved to have to prove a fault case. There may be reasons to do that. There may be good reasons to do that. But if you can have the option of no fault and know that you can have the support that you are entitled to because you have put so much effort into keeping the family, raising the children, keeping the home, all of the things that people sacrifice to do for their own personal reasons, and then they have nothing when they get divorced because they haven't been out in the world to earn. And that is the purpose of the alimony, is to help have some fairness. And the last thing I'll say about that is the alimony law that we have right now, the first step is for the court to see, does the person seeking alimony have a need for that alimony? And the court needs to analyze that. They can look at the earning capacity of that person, their education, their background, all of those things to determine if they have a need. If they say yes, then they look at the other party's ability to pay. And that's after they're meeting, their reasonable expenses. And you sort of look at the lifestyle that the parties have been accustomed to, and you know that people reasonably need to adjust that when they're splitting up. And then we apply a formula in order to figure out the amount and the duration. The duration's half the length of the marriage. So you're married for 20 years, you get 10 years of alimony if you qualify. Okay, so say you're 40 years old, you stayed home, 20 years of raising children, you get 10 years of alimony. So that's just a practical way that it operates, that this legislature and this committee passed in order to have a fair way to handle this issue. So this would completely dismantle it, and that's why we ask you inexpedient to legislate. Thank you.
Some of us in this committee were also members of the Special Committee on the Family Division of Circuit Court. And as such, we at least one day, and a few of us more than one day, shadowed family court. And we saw the various things in real time on the ground that take place in these kinds of matters. Would this bill take away judges' discretion in some way by simply saying this is eliminated?
Well, the judges would not be able to order alimony unless there were fault grounds that were proven. And so with the fault grounds, that's very much in the judge's discretion to determine whether there are fault grounds.
I see. I've asked my question backwards. Sorry.
Okay.
But it would, in your experience, heighten the number of divorces that are no longer no fault, but divorces for cause. which, in your experience, is time, effort, and money to prove.
Yes.
Thank you.
It would heighten it if we think back 50 years before we had no fault divorce. I mean, people had to, if they wanted to get divorced, figure out who's going to take the hit on fault, right? And now we've got to prove it. So, like, they might agree to it, but you're not, you know, there are New Hampshire Supreme Court cases that we have back in the 1800s where people didn't get their divorce because they couldn't prove fault. I mean, it is a very high bar, which is why we have no fault. So you will have people who need alimony to live, trying to figure out how to squeeze their situation into a fault ground. That's sort of where we were 50 years ago. How do we squeeze the situation into a fault ground so I can get divorce?
Questions for the counselor? Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. So I'm thinking about a hypothetical situation, but this is what happens with actually a lot of people that I know, where the marriage has run its course and both parties have agreed that they want to get divorced. It's not a high conflict divorce. They're in agreement. They want to get divorced. And they, on their own, have decided that because one spouse is either unemployed from raising kids or underemployed, that the other spouse wants to provide alimony. Would the changes to this bill eliminate that possibility? Because it says that the judge can only order alimony in divorce cases decreed in favor of the innocent party. So would that impact these people who have already decided on their own that this is the arrangement they want with their spouse that they still like, they just don't want to be married to anymore?
I'm just reading it again. So it says the court may order term alimony solely, this would be the new language, solely in divorce cases decreed in favor of the innocent party under 458(7), comma, upon agreement of the parties. So I think the parties could agree under this. And if I could just add, I think parties do agree that that definitely happens. And I think we will change the law in order to make it easier for them to predict what alimony would be, what the obligation would be. It's the cases where people proceed on irreconcilable differences and one party requests alimony and there's not agreement about that and maybe some other things like property division and other things like that. And so the court is having to hear that case. And that's the case where then you're going to for sure see people now pleading fault, probably both directions.
Right. I think this committee has heard lots of testimony from the court about the 10 to 15% of divorce cases that take up all their time. Yeah. So thank you.
Representative Markell, you are an attorney. Would you care to weigh in on this bill?
Yes, Mr. Chairman.
Thank
Thank
you,
you. I
sir.
can. Let me get that on there. Okay. I happen to agree with your testimony, Attorney Kruger. And fault grounds are exceedingly difficult to prove. As a practicing attorney, I can tell you that's been my experience. And this would unduly restrict a party's right to be able to ask and receive alimony. I'm also, with respectfully disagreeing with the prior witness's testimony. I am unaware that the United States Supreme Court or any court has ever decided that alimony constitutes a violation of the 13th Amendment to the federal Constitution, or the New Hampshire Constitution for that matter. So I would support this, and when it comes time to exec this bill, we can weigh in at that time.
Anyone else with a question? Seeing none? Thank you very much for your
Thank you.
testimony, Counselor. And this concludes the hearing on House Bill 325. Open the hearing. No, I don't. I open the executive session on House Bill 325, and the chair calls on Representative Markell for a motion.
Okay. Thank you, Mr. Chairman. I move that we decide that this bill is inexpedient to legislate.
And for the second, Representative Grossman. Discussion. Representative Di Simone, where you pronounce all the letters.
Thank
For those of you
Mr.
who are new, by the way, we had this discussion last term that in Italian you pronounce all the letters. In French, you don't. So, and thank you for Representative Petrino for bringing this to the committee's attention, sir. Thank you.
Thank you, Mr. Chairman, and thank you for that tutorial on our names. It makes it easier for us to pronounce. Again, I co-sponsored this bill because I always believe that there's room to enhance a particular RSA when it comes to helping people through some of the most difficult times in their family life. It is now to my knowledge, that this bill does not in any way, manner, or form enhance any of the laws that we have. I am plagued with the thought that somebody thinks that paying alimony is tantamount to slavery. I don't know where that thought process came from, and I'm not going to question it, but what I do question is that when you marry, it is a contract. In business, when you enter into a contract, like with a marriage contract, there is an uncertain date sometimes as to how the length of that contract, and a marriage contract is usually an unspoken lifetime. And when that contract is broken, sometimes a person needs help getting themselves back on track again. That's one of the reasons for alimony. In business, you buy out the contract. I don't think that the other party is being bought out, but I think that if you want to relate a contract to a contract, that's the only way you could coldly do it without feeling. Men and women who are in a contract with their partner deserve the opportunity to be educated or have the time to get a job that will help support themselves and their family, and that's what alimony is all about. Therefore, I 100% support the ITL motion. Thank you, Mr. Chairman.
Other comments? Representative Georges.
Thank you, Chairman. I just want to, this is just my testimony for myself. Because for the things, I was divorced. I did a lot of work. But after 20 years, I was just, my ex-husband was asking divorce. But what the court did, everything, like this, they didn't give me anything, not the alimony, but I was paying. I was not working. I was going to school. I was paying the mortgage. I was taking over the kids, and the only one thing I was just getting the Social Security for the kids. But when those kids become 18, it was just when one just became 18 after 1 year, and then another one I stay with. But I never get the alimony. But I suffer. And I see all those women and that man, all the money we was making was building the house in their country, because we are not the same country. I come from Africa, I come from Haiti. He built a big house there, and now staying in Nashua with another woman. And he was sick. He was in a car accident. I support everything. The doctor even said for me now go to work because I need to support him. But they never gave him alimony. They suffer. I think so. I am going to be with those women. They need to give them alimony, because this is not something we can just accept because to eliminate it. I'm just I support the TLC. Thank you.
Thank you, Representative. Anyone else? Representative Nelson.
Thank you, Mr. Chairman. This isn't just exclusive to women receiving alimony. It's the opposite way too, and I just wanted to make that clear for the record.
I know of a few instances of that. Anyone else? Representative Love.
Thank you, Mr. Chair. I think we ought to be real careful as far as putting laws together and voting on laws that encourage divorce. This without this, we're encouraging what happened to me. I was working 16 hours a day. I got hurt. Couldn't provide the financials. The financial for the home, and my ex-wife came up and said, "I'm not having fun anymore. We're done." Okay, where would that leave a guy like me? I think this is a good idea, but I don't like alimony. I think it should be an individual agreement. In each individual divorce. If it fits, fine, and if it doesn't, but there's no fault. No fault divorce has been a burden to society in my eyes. And to I think this would be a step in the right direction, but probably needs some work. But I'll be voting for the ITL, but I'd like to see something that would something like this that we could work on and come up with something better than what we have.
By way of example and a positive shout out, Representative Spillane has been bringing bills on the same topic 3 or 4 times now, because we would say close but no cigar, which was not a put down. It was, we can't vote for it just yet, and take the testimony that we all made and come back, and he's come back, and I think this time we may see 1 or more of his bills make it. So maybe that is the case with this and some other bills. And any thoughts that you have any thoughts that any of us have for the prime sponsor of this to possibly make this passable another time? I'm sure this prime sponsor would welcome that. Anyone else? Representative Gregg?
Thank you, Mr. Chairman. I think one thing that we've talked about certainly when we were on the special committee on family courts, and within this, I almost said this chamber, I don't know whatever this room, we've had a lot of discussions about the separation between what we do legislatively and what the judiciary does. And certainly when we're talking about alimony, we're talking about things like this is a one size fits none situation. So really leaving that to the discretion of the judge. The judge does not always award alimony. That's just not 100% thing. And I think that that's really where that still belongs.
Thank you. We're going to take anybody who hasn't testified yet, and then you get another shot at it. Okay. Anybody else who hasn't, while Representative Georges is pondering her second bite at the apple? Representative Markell, do you wish to weigh in briefly on this?
I think the bill is inexpedient to legislate. It's difficult to implement. As Attorney Mary Kruger pointed out, and in my experience litigating divorce matters, fault grounds are exceedingly difficult to prove. They also have, in terms of implementing them, it's not only that you pled fault grounds, there have to be certain other statutory factors that have to play into it as well. And for a court to consider it the proximate cause of the breakdown of the marriage, this would make it exceedingly difficult, and I don't think it's going to solve any problems. So I would renew my motion for an ITL.
One more? Representative Georges?
Thank you, Chairman. I just was trying to make sure there is a lot of people sometimes, they don't even know much about the law and about all those things for the divorce. Like when I went for the divorce, I didn't know anything, but to help people like when I was at this time, I think so for today, I know a lot of things, but at the time I didn't even know what I'm supposed to do, who can help me. We are here to help the community, the people like this. Thank you.
Representative Grossman?
Thank you, Chairman Pearson. And just to piggyback on what the representative was saying, alimony can be associated with such a dirty word, And until someone begins that process, it's restorative. It is not meant to be negative. It's meant to be restorative. However, on the way that many people look at it, it's like this bad thing. However, when we look at the process and the meaning for it, and if someone was at home raising children, overly qualified with a master's degree, you know, there should be some discretion whether alimony should be awarded after 20 years or not. So I will not support this bill.
The motion before us on House Bill 325, eliminating term and reimbursement alimony in divorces granted on grounds of irreconcilable differences, moved by Representative Merkel and seconded by Representative Grossman. Would one of the clerks call the roll, please?
Chairman Pearson,
Yes, this is yes to ITL, or no to ITL. It is the negative motion. So, yes.
sorry. Representative DeSimone,
Yes.
Representative Rice,
Yes.
Representative McMahon.
Yes.
Representative Nelson says yes. Representative Seidel,
Yes.
Representative Love, Representative Cozen,
Yes?
Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
unanimous. $16 to 0.
The motion of ITL is unanimously approved, 16 to 0. Why, let's see, would we like it on consent? Yes, we would. Thank you for asking. So it goes to consent. This concludes the executive session on House Bill 325. And since we have approximately 15 minutes, those clocks are fast, that one especially, with the permission, with the encouragement of the ranking member, I open an executive session on House Bill 170 from last week, which was Chairman Moffat's bill. This bill removes military retirement benefits from property settlement agreements as a result of the dissolution of the marriage in the state of New Hampshire. And I'm trying to think who was lined up to make that motion. I don't remember either, but I can find out. Yes, it was Representative Markel.
Thank you, Mr. Chairman. I move.
Would you care to
Okay.
make a motion?
Yes, sir. Thank you, Mr. Chairman. I move that we declare that to be ITL inexpedient to legislate.
Thank you, sir. And Representative Raymond. And now we may discuss it. And I will say that I've had a conversation with the prime sponsor. He understands the concerns that we have in with this bill. Representative Gregg.
Thank you, Mr. Chairman. I think that we voiced and discussed some of these concerns last time, but it kind of is on theme with where we are today. It's the same situation with alimony, being that military spouses have an even larger burden as far as, you know, moving, not being able to work, all these things. And so this is a necessary thing. And as Representative Grossman so eloquently said, this is about restorative things when a marriage fails. And so this bill troubles me that it would take away that restorative feature.
Thank you, Representative. Any further comments? Representative Raymond.
Thank you. I agree. I also want to just point out that I think that, as the chairman was saying earlier, there are some bills that people listen to what we have to say and then they come back with a change I think in this case, part of the issue was that that this was a one size fits all or one size fits none. So I think if someone came back and said, we want a bill that would have judicial training so that the judges know that it doesn't have to be 50-50, it can be case dependent, that would be something that I could get behind. Because judges do have discretion and they shouldn't be doing 50-50 in every case. They should be looking at all of these criteria that are set out by the U.S. Former Spouse Protection Act. And so I would love to not just quash the idea of making changes that help people, but like really focusing on how do we make the changes so that they apply to a wide variety of circumstances and not just one person's experience.
Representative Love.
Thank you, Mr. Chair. Yeah, I won't be voting for the ITL for the reason it's not a pension. Even though it says pension up the top, we heard that it's a retainer. Okay, meaning, if you and I had a contract, I retain the right to call you back to work, and here's some money for you to do, for us to do that contract. We're not talking about alimony. We're not talking about child support. This is just it's not property, as a pension would be, or IRAs and things like that. This is still an active act that the retiree has to he's obligated to. It's the government. They're restricted to their conduct mandates could cause them to lose it. Their employment, they can't go overseas and work for as one guy said, work for Saudi Arabia, without approval. This isn't just a plain everyday retirement account that so many of us are used to. This is something much different. And like I said, I'll be voting against the ITL.
Anyone else wish to speak to this? Representative George.
Thank you, Chairman. I think so, except for if there is for the good cause. And like the Chairman Raymond said, for 50-50 to look what they are going through and then what they do, or for the property. They cannot put that like in a pension inside if they give everything. Because I see like it's a lot for one person. For me, that I see like it's a lot for one person. They can go 50-50.
Representative Markell.
Well, I can respectfully disagree. It is a pension. Even though it was characterized as not being a pension, it also requires the equivalent of a qualified domestic relations order to be able to transfer the plan participant's interest to the alternate payee. So it has to go through a specific military process for it, and it's rather complicated. So the other thing is, in closing, is that it's only one part of the marital pie. In New Hampshire, when people marry, virtually everything they have, which is both assets and debts, enters into the marital mix. The pension rights in the military are only one aspect of it. And to separate that out, I think, is going to undermine the purposes of the present statutes. So I respectfully renew my motion to ITL it.
Thank you. Anyone else? Seeing none, the motion before us is on House Bill 170 relative to the division of military pensions during divorce proceedings. And it was moved by Representative Markell and seconded by Representative Raymond. And when ready, the clerk may call the roll, please.
Chairman Pearson,
Motion is ITL. Yes.
Representative DeSimone,
Yes.
Representative Rice,
Yes.
Representative McMahon,
Yes.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love, Representative Corzine is yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
Representative Malone,
Yes.
15 to 1.
15 to 1, the ITL motion passes. It can go on consent with the approval of the negative vote. Otherwise, you get to write a report. Okay? Don't consider that a threat, just a promise. On to consent then, yes. And this concludes the exec session on House Bill 170. Before we move on to the next bill, this meeting, as there is every Tuesday morning with the chairs and the vice chairs, and apparently there's been all manner of breach of proper decorum and etiquette in some committees. And as this was being mentioned, I'm sitting there saying, nope, not us. Nope, not us. Isn't it fun, even when we disagree, to work well together? That's what we try to do here, folks. So thank you. I'm sitting there saying, can I put my hand up and say, that's not us? And I decided not to, because I think our reputation is yes, a golden star. All right, moving along. Open the hearing on House Bill 433. In 4 minutes. Thank you. I was looking at the clock after I said it's too fast. Thank you. and removing the language regarding age waivers for marriage registration records, since age waivers are no longer issued in New Hampshire. The chair recognizes Representative Margaret Dry, the prime sponsor.
Thank you, Mr. Chairman, and thank you, committee, for hearing this bill. For the record, I'm Representative Margaret Dry. I represent Sullivan County District 7. And I'm here today because life throws curveballs. Experiences in my own family and friends of parties being married at 17 years of age have convinced me that sometimes that is an option that works. When the marriage bill passed last year, raising the age of marriage to 18 with no exceptions, I immediately thought of exceptions where it might be nice to at least have an option on the table. And one exception that immediately struck me as reasonable and logical is those on active duty in the military. This exception shows up, for example, in the state of Alaska, where the age of marriage is 18, but there is an exception for those on active duty military. The age of being able to support a child, or have to support a child medically or by child support in our own New Hampshire statutes declare that stops when someone becomes 18, becomes emancipated, or is on active duty in the military. That triumvirate appears in other places in our law where people are considered adult by being either over 18, emancipated minor, or in active duty in the military. All branches of the armed forces have 17 as the minimum age for recruitment. Military benefits, such as medical coverage and insurance, are only given to spouses, not to girlfriends, not to fiancés. Only spouses can get housing or accompany those stationed overseas. I sent 2 sons to Iraq in the Marine Corps. I realized as I watched them leave the house that there was a very real chance that they might not come home. We have a volunteer military now, but if we ever do have a draft, marriage might be an option that some would like to choose. This bill has been crafted as narrowly as possible. At least one party has to be active duty military. At least one party has to be a New Hampshire resident. We don't want New Hampshire to be Las Vegas, where people come just to get married. And any party who is not on active duty military but is 17 must have parental consent. There may be people here today that call this child marriage because you're 17, but I have never heard a 17-year-old soldier be called child soldier. Persons in New Hampshire can give consent for sexual contact with adults at age 16, but marriage is forbidden until 18. That's quite a disconnect. We consider 16-year-olds old enough to consent to sex, but don't consider 17-year-olds old enough to consent to marriage. I have received a bulk email from all over the U.S. asking me not to bring child abuse back to New Hampshire. But perhaps the age of consent law is the child abuse, and the ability to marry in the case, for example, of pregnancy would be child protection, that is, protecting and providing for the child that is on the way. I am not changing the law in New Hampshire. This bill does not repeal last year's bill. I repeat, this does not change the law. It merely adds a narrowly crafted exemption, providing an option for those who put their lives on the line for our country to provide for the ones they love. And I ask you to vote this bill ought to pass. And I would be happy to answer any questions.
Thank you, Representative. Any questions for the prime sponsor, Representative Levesque?
Since the
Thank you, Mr.
Thank-
Whatever I am. Yeah.
Sorry. Thank you, Mr. Chairman.
Chairman? Oh, thank you.
Sorry, haven't had that much coffee yet. it's in the other room. Since the marriage law hasn't been in effect for 30 days yet, do you see that this bill is necessary? Or do you think that we should give this more time to get into effect so that way if there is a problem we can address it next term?
Well, if you remember, thank you for the question. If you remember last year, that was an there were some attempted amendments at this, and there were exceptions brought up that would have liked to have been added to this. I felt at the time that it was just a cutoff without much discussion about whether there could be some exemptions. So I'm thinking that while it is new and this is a good time to add exemptions.
Follow up.
And do you see an issue when it comes to if the couple do get married and then try to get a divorce, and due to the Service Members Civil Relief Act could come into effect when it comes to them being overseas and their partner is trying to get a divorce, and divorce proceedings have to be on hold until that member comes back. And I don't want to think it, but some members may extend their deployment so that way they don't have to get a divorce.
Thank you for the question. I think that's a worst case scenario, and I'm looking at there will be other cases that'll be better scenarios.
Other questions? Representative Raymond.
I actually, thank you, Mr. Chairman.
Welcome.
Goodness, it just happened too. I don't know where my brain is
Only
today.
2 weeks back.
So thank you, Mr. Chairman, and thank you for taking my question. I appreciate it. My question is about active duty military. And so it says in the bill many times active duty. And I don't know the definition of active duty, and I wondered if you could explain it. Does that count like basic training, or is it not till after? Like at what point does active duty start?
Starts with basic training.
Okay. So is it as soon as you've signed the recruitment letter, or after you have been sent down to wherever you're going?
That's a better question for somebody who might have military experience.
Okay, I'll ask when they come up then. Thank you.
Representative Georges.
Thank you, Chairman. Thank you for taking my question. I just, there is some kids graduate like at 17 years old. And there is not to everybody, because I know all my kids, most of my kids just have a graduate at 18, but the youngest graduate in 17. But not every kid finishes school at 17. That's the reason maybe she cannot go to the military. But if he graduate at 17, that he can go to the military. And for you think so the 17 years old girl, she's ready with a mind to take care of really the family. She can take care of the family to be married.
Well, I think she should have the ability to make that decision. She doesn't have to choose to do this, but the ability is there to make a choice to get married. And she needs parental consent if she's 17.
Follow up?
One follow-up, yep.
Thank you. I know she have ability, but not everyone. The problem is if one can do it, not all of them. Some of the kids, they're not really mature. That is a problem too. It's for one person can be very smart, can just go do everything, but not all of them. This is the problem. We cannot just not.
Please make sure this is a question. The testimony can be for the exec session. This is to elicit answers from whoever is at the chair.
Okay, I'm sorry. Just my question, just like
Again, second week.
Yeah.
We're new. Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. Representative Dry, would you believe that I left my household at 17 years of age and I cohabited with an abuser, and I was not able to seek help as I was a minor? And would this enable somebody to seek help if they are of married status.
Oh, could you repeat that again? I'm not sure how this relates to this.
So, thank
how
you.
does it
I'm
relate?
sorry.
That's all
Okay,
right.
thank you for the question. So, what I'm saying is that when we voted on the age of marriage being raised to 18, 17-year-olds no longer are able to go to a domestic violence shelter and be cared for without being afraid of, especially if they're young mothers, of being separated from their infant, because she would go to one foster home and the child would go to another. However, my question is, if that 17-year-old mother is emancipated, she would have the same rights as a person in the age of majority. Is that correct?
I believe so, but that really is not tied to this.
This is not
bill.
part of the bill. Make sure your questions are about this bill for active duty military folks. Other questions? Representative Levesque.
So with the active duty, thank you, Mr. Chairman. With the active duty military, I looked at your bill and it doesn't specify an age limit when it comes to active duty military, because just doing a little bit of research beforehand, most of the military branches go between the ages of 17 and 42. And is there any, would you consider having a age stop for this bill, so that way we don't have a 42-year-old man or a woman marrying a 17-year-old child?
The idea is that, thank you for the question, this bill makes this active duty person an exception to the 18-year minimum. They would be then 17. Okay, because that's the year that you can be in the military but not yet have reached the age of marriageability in New Hampshire.
Representative Petrino.
Thank you, Mr. Chairman, and thank you for taking my question. I could have missed it, and I apologize if I did. But what is the motivation behind the legislation in terms of making an exception for someone who is 17 just because they're in the military? I mean, why not make an exception for all 17-year-olds? You're 17, you're in love, you want to get married. So I could have missed it, but what do you think?
Thank you for the question. Well, some of this came from my experience as a military mom and understanding kind of what you leave behind when you go overseas. Both of my sons saw active duty in the war in Iraq, and it was very troubling for the family left behind. I think that we are very fortunate that it is a volunteer military right now. But at the time I was looking into this, things were heating up in the Middle East and things were heating up in Ukraine, and the word draft floated around a little bit. And I realized that if we wanted to allow this exception for a time when there was a draft, the wheels of government move very slowly, and I would rather have something on the books. I'm not expecting a landslide of people to come who are 17 marrying 17-year-old active duty military, but I would like this option to be here on the books.
Representative DeSimone.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. Taking into consideration your statement about the age of 16 as the age of consent, and I'd like to move you forward to this type of a scenario. You're 17 years old. You're engaging in that behavior with an 18-year-old military man or woman who goes off overseas or to another part of the country. A pregnancy takes place. The military person may not be back in your vicinity for 2 to God knows how many years. The child is born and now doesn't know the other parent. The other parent doesn't have any interaction with that child on a regular basis, can't hug them, hold them, walk the floors at night with them. What kind of an impact do you possibly believe there could be, not only on the adults, quote unquote, but the child?
Thank you for the question. If I understand it, you're asking the benefit to the child and this person, and I couldn't understand if they were married.
I'm asking you if they were not married, they would not be able to, the mother would not be able to be on the same base as
Okay,
the
thank you.
military person, or in the other case, the mother could be on base, give birth to the child, and the father wouldn't be able to be on base if he were 17. So I'm asking you, how detrimental would that be to the child and the family unit later on? Because they may not be able to marry for 4 to 6 or 8 years.
Thank you for the question. Now I understand. Yes, I believe this is not only in the benefit for the physical, material benefits that come with marriage, including insurance and medical insurance, but I just realized how much the benefits of housing and being maybe perhaps able to accommodate someone traveling overseas makes a difference. Soldiers think about home when they're not in the United States. And if they're provided for well at home, I think they rest a little bit easier. And I think that, yes, I agree that it's more, goes beyond just kind of physical benefits, but there are things like housing that you need to consider, and how strict the military really is about it being a spouse. Thank you.
Thank you, Representative, for your testimony.
Thank you.
Because I have a
copies to give
mitt
you.
full of cards, I will exercise my right as the chairman of this committee to limit every subsequent testimony to 3 minutes. 3 minutes means 180 seconds. At 2:45, I will let you know 2:45, and at 3, I'll shut your mic off. Now, this should not be a problem. Most of you have requested 3 minutes or less. And last term, the best speech I have ever heard in 9 years in the House was 47 seconds. It was precise, it was on point, it was compelling. With that, the chair recognizes Representative Katie Peternell to speak.
Good morning, Chairman Pearson and members of the committee. Thank you. For the record, I'm Katie Peternell. I represent the towns of Wolfboro and Tuftonboro. And Representative Dry told me about this bill just yesterday, and I thought, oh, that's definitely something I can get behind. I know a perfect example of why this bill would be necessary in a very small number of situations. But as I was listening to her testimony, it occurred to me that this is a really beneficial bill also to our military. And I'll use my story as an example of why that is. I have a friend who found out when he was 18 that he had fathered a child when he was 15. At the same time as he was turning 18, he discovered he had fathered another child. And he was doing drugs and getting into all kinds of trouble. So now he had 2 children, and he needed a way to provide for his family. And the way out was to join the Navy. And he was able to provide for his family and have an exceptional military career in the Navy. In fact, he almost retired at one point, or left the Navy at one point, went into recruiting, realized he had fallen back in love with the Navy, and continued out his 20 years, and bears that very proudly. So I think this is a situation where it is helpful to a very small number of people in this situation, but could also help somebody out of a very challenging life situation. I mean, and we have declining enrollment in the military, and we need these young men willing to step up. And if they have a family, that gives them motivation to step up and serve their country and take care of their families.
Thank you. Any questions for the representative? Seeing none, thank you for your testimony. The chair recognizes Major Shelley, is it Hoyt? Hoyt. Fellow Air Force Major, thank you for your service. And the hardest thing is to remember to turn on your mic. Bingo. Now the clock starts.
Thank you, Mr. Chairman. Good morning.
For the record, I'm Shelley Hoyk, a retired major in the United States Air Force. I live in Hopkinton, New Hampshire. I'm here to speak in opposition to the proposal that would allow New Hampshire children to marry military service members. I will speak to 3 of the unique realities of military life which make this proposal dangerous for our children: the transient lifestyle of military service, the uniform code of military justice, and the financial pressure faced by young military families. The life of a military service member is transient and unpredictable. In my first 2 years in the Air Force, I had 5 permanent out-of-state moves. The shortest was 6 weeks in duration, and the longest distance was Okinawa, Japan. This is relevant because every time a military spouse arrives at a new duty station, he or she is completely isolated until he or she creates her own support system of friends in a new community. This support system is your lifeline when your service member is called away. Can you imagine being a 17-year-old child, hundreds or thousands of miles away from everything and everyone you know, trying to develop a network of friends? She won't be successful. When the military member is away, she will literally be home alone for months at a time. What if the military member isn't deployed but is abusive? This happens in the military. To whom can the child's spouse turn for help? You're thinking, call the police. That brings me to my second point of military life. The MUCMJ. Military law is different from civilian law in that a service member's commander has sole discretion of whether and how to punish any crime committed by that service member on base. I volunteered with the Rape Crisis Council when I was stationed in Okinawa, Japan. I saw firsthand how commanders make the decision of whether and how to punish members of their own team. I specifically recall the case of a female Marine who was raped in her own bed. The facts were uncontested. The male broke into her locked dorm room while she was sleeping and had forcible sex with her. There was no prior relationship, and she did everything right, screamed for help, called the police, fought her attacker, submitted to the exam, and filed a complaint. I was there when the decision was made not to punish her attacker. No lawyers, judges, or police were present. The commander opted not to pursue the punishment because it would unfairly mar the clean record of a Marine who had a promising career. If this is how they respond to violence on one of their own, a fellow Marine, how high do you think a commander is going to value the well-being of a 17-year-old child from New Hampshire? The third relevant reality of military life is consistent.
2:45.
The third reality is the financial struggle that these people face when they're a young military member. A 17-year-old without a high school diploma or with one is not going to be able to compete for an on-base job.
Time.
Thank you for hearing my testimony.
And any questions for the major? I think I have to wake up now. Representative Grossman.
Thank you, Chairman, and thank you so much for being here and for your service as well. And just a comment to thank you for that and for your testimony. And when I was born on a military base in Germany, my dad was in Okinawa, so I appreciate that. Thank you.
Thank you for the
Any other questions? Representative Raymond.
Thank you, Mr. Chairman. And thank you so much for testifying and taking my question. So I'm going to go back to the when does active, it says in the law, the language says active duty. So when does that start? Does that start when you go to the Air Force Academy? Does it start when you finish basic training? Like at what point is this person active?
Thank you for the question. In my understanding is that the day that you show up at the MEP station, this is for enlisted personnel, when you show up at the MEP station, you raise your hand and you're sworn in, and then you get on the bus to go straight to basic training. That's the moment when you're active duty. A cadet in the armed, in the schools, service schools, is not active duty, and they're not allowed to marry until they graduate.
Okay.
I'm sorry, I might be wrong about whether they are active duty, but they are cadets, and they're not allowed to marry until they graduate.
Follow up.
Thank you. So, so I guess my question is then, procedurally, how would that work if someone is wanting to get married to their high school boyfriend or girlfriend, but the person has to go off to basic? If they're active when they get sworn in, but then they have to literally get on a bus and leave, is there an amount of time in between? Or is it they have to wait till the 6 or 8 weeks of training is done?
I'm not sure whether, I mean, there are moments and hours that you're waiting for the bus after you sign in. There could be a special logistical. I can't answer that intelligently. I'm sorry.
Thank you. I'm sorry. It's been, I'm old enough that it's been quite some years since my high school boyfriend joined the Coast Guard, and I don't remember how it worked. I don't think I went with him to the swearing in. So thank you.
Any other questions? Okay, you're backlighted. Yes, there you are, Representative Levesque.
Thank you, Mr. Chairman, and thank you for your service. My dad was a Air Force vet, and he enjoyed it very much. My question is, so when you sign up for the military, there you were given like a stack of paperwork, which can be overwhelming. In there, is there a paperwork that you can sign that lists anybody as the beneficiary to receive the benefits from the military?
You're testing my memory. Thank you for the question. As I recall, it doesn't happen until after you get to basic training. You go to a whole bunch of different classes, and in each one you learn about a new form. And so it's during basic training that you assign beneficiaries in my long ago experience.
Thank you, Major. Thank you for your testimony and for your service. Chair recognizes Representative Terry Roy, followed by Emma Savini, followed by Representative Harry Bean.
Morning, Mr. Chairman, members of the committee. Thank you. Representative Terry Roy, Rockingham 32, Chairman of Criminal Justice. I'm here as a co-sponsor of the bill today and here to testify on behalf of the bill. To be clear, I don't think getting married at 17 is a great idea. I think if we had the power, we should maybe make it 35 before you can get married, maybe older. Having said that, November 13th, 1986, I was 17 years old. I reported to the MEP station for basic training. I was 17. I just finished high school. I was young for my class, one of the youngest in my class. My first duty station, I was sent over to West Germany, a country that doesn't even exist anymore. That's how old I am. I'm older than some countries. Having said that, I was not probably smart, but lucky. I wasn't married, didn't need to be married, but I can see the reason for this exception. And I would urge members who fought so hard for the 18-year-old not to see this as chipping away at your work or loosening it. This is a very fine exception whereby if a soldier goes to basic training, sometimes there is a break in basic training. I heard the question brought up. I went to basic training in November. We had, I forgot what the term was, but at Christmas we had a break. And we went home for 2 weeks and we had to go back, which was horrific. I wish they would have never done that because it was like starting basic training on day one again. Having said that, there is time before that, and there's several weeks usually before you get shipped off to a duty station. If you have the unfortunate luck that you made a bad decision and your partner is pregnant and you are getting shipped over to another country for your duty station or the other side of the planet, she needs medical care. She needs prenatal care. That child's going to need medical care, and the military is not going to provide it unless they're married. So that is so important to get that prenatal care and to have support for her. Even if she can't go with you, the military has extensive support networks to help single spouses that are back there waiting for their soldiers. So I would urge you to look at this from that perspective. This is to qualify. It's probably less than 0.1%. But right now, somewhere out there in New Hampshire, there might be a pregnant woman right now wondering how she's going to take care of this child because her soldier is being sent away. So I would ask you to consider it as that. It's a narrow exception. And I'll take any questions.
Any questions for the representative?
Any questions that don't relate to how old I am or 1986?
Thank you for your testimony. Thank you for your service, Representative.
Thank you.
Next up is Emma Savini, followed by Representative Harry Bean. Emma Savini from New Futures.
Good morning, Chairman and members of the committee. Thank you for having me today. For the record, my name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures, and we are here in opposition to House Bill 433. New Futures is a nonpartisan, nonprofit organization that advocates for the health and well-being of all Granite Staters. We are here in opposition to House Bill 433 because child marriage is inherently dangerous and produces devastating lifelong repercussions to children's health, mental well-being, and financial and educational opportunities. Marriage before a minor reaches the age of majority clearly falls in opposition to children's behavioral health strides that we've made in our state in the past few years. Emotional, physical, and sexual abuse are common in marriages that involve a minor. And these events are commonly referred to adverse childhood experiences, or ACEs. ACEs have lifelong and devastating consequences to an individual's health. It's been linked to things such as higher rates of substance use disorder, higher rates of suicidality, depression, anxiety, heart conditions, diabetes, human trafficking. All of these outcomes are only with 4 ACEs in your childhood, are tied to only 4 ACEs in your childhood. The good news is that ACEs are preventable, and New Hampshire has already done what needs to be done to prevent ACEs in child marriage by eliminating, without exception, child marriage. This legislation would roll back that progress that we've made. And so for those reasons, New Futures urges this committee to vote ITL on House Bill 433. Happy to take any questions.
Any questions? Seeing none.
Thank you.
Is that a writing or? Okay, so thank you for your testimony, and my love to Chloe as always. You're welcome. Representative Harry Bean.
Good morning, Mr. Chair and committee members. I'm here in support of House Bill 433. I think that it's necessary to make sure that if somebody under the age of 18 that might be a parent, because the law is 16, you might be a parent when you're 18. But if you can't get married and you go off to war and God forbid you get killed, I'd like to see some kind of military support for the family. I got married when I was 16. I've been married for almost 54 years. When I got married, I quit school, and they said, you'll never make it. I had 2 kids by the time I was 18, bought my first apartment house at 18. My wife and I knew each other pretty good, but our parents, who had to sign legal consent for us to get married, knew us way better than anybody in this room, guaranteed. Without the parental consent, it'd be questionable maybe. But so we've been married almost 54 years. Bought 8 houses, 7 duplexes, 2 3-apartment buildings, 3 4-unit apartment buildings. And she just left here with my great-grandson, Harry Bean VI. We have 3 children, 8 grandchildren, and 6 great-grandchildren. Marriage under the age of 18 works if the 2 people are committed. And the parents have to know their children. You know, there are some children that are not going to do it, but the parents ought to know that by the time they're 16. They ought to know if the kid is on the ball or if he isn't, I would think.
Half a minute left, Rep.
Yeah, well, I'm all done anyway.
All right.
Thank you very much.
You're welcome. Any questions on how to be a great-great-grandparent?
Start early. Sorry.
Thank you for your testimony, Representative. Chair recognizes Brittany Wright, flown in from 91945, which is somewhere in California, I bet. I've done bulk mailings before. Where in California are you coming here from?
Thank you, Chair. San Diego.
Oh, big military place.
Yes.
Okay, clock starts. Go ahead.
Excuse me. Chair Pearson, Vice Chair DeSimone, and distinguished committee members, thank you for taking the time to discuss this issue here today, and what a privilege it is to participate in the systems that allow each American's voice to be heard. My name is Specialist Brittany Wright, and I'm here to testify in strong opposition to Bill HB 433. After years of abuse at the hands of an adult man, I was taken across state lines, and when I was recovered by the police, my parents forced me into a marriage to my childhood abuser. I escaped at 18, and the divorce left me homeless, with no one to turn to for help except the greatest military force this world has ever known. I put my nose to the grindstone, as they say, and with multiple attempts, I passed my GED and I joined the United States Army Military Police Corps, where I served 7 years. Signing a contract with the military gave me access to expansive training and resources that I still use to this day. Training and resources that have made me stronger, healthier, have made me a better mother, and they have given me an education. Training and resources a married, emancipated minor does not receive as a result of signing a legally binding contract that is a marriage license. Child marriage gave my abuser, an adult man who at the time was in the military, the power to groom, molest, and rape me at 14 years old, take me across, which is a Class B felony in the state of New Hampshire, take me across state lines without the consent of my guardians, which is a Class A felony in the state of New Hampshire, marry me at 17 years old, and walk away from a number of criminal charges with a child bride he could then legally rape. When we allow child marriage under any exception, we allow grooming to take place in our society, period. Every military member serves for their own reason. Like my father and my grandfather before me, I served because I love this country. And I served to rebuild the life that child marriage stole from me. And I still serve my country here today by standing up for the most vulnerable among us. Next time you thank a military member for their service, remember me and remember my story. Do not
15
thank
seconds.
me. Do not thank me for my service. If you plan to use it as an excuse to justify the abuses that occur if we allow child marriage in our society under any circumstances, under any exception.
Time is up. Any questions? Representative Gregg.
First of all, the sincerest thank you for your service and for your bravery in telling your story. I know that's not easy. Oh, thank you, Mr. Chairman, for letting me do this. And thank you for taking my question. So just to clarify, at 17, your parents signed permission for you to marry someone.
Thank you, Representative. Yes, that is correct. Children do not consent to marriage. Their parents consent to marriage.
I was listening to your genuinely heartrending story, and I wonder, would it not been pretty similar if you were actually 12 months older?
That's a fair question, and yes, because I would have then been a legal adult.
Which would have meant,
Which would have meant that I had access to divorce, which would have meant that I would have had access to health care without the permission of my spouse, who was clearly not interested in my well-being.
thank you.
Thank you, Chair.
Any other questions? Representative DeSimone.
Thank you, Mr. Chairman, and thank you so much for taking my question. After you turned 18, how long before you divorced the horrible person?
6 months.
Follow up?
Follow up.
Thank you if you'll take a follow-up. Are you aware that in New Hampshire you can file for divorce at 17?
I am aware.
Thank you.
Seeing no other questions, thank you for your testimony. Chair recognizes Aaron Hearn from Hanson, Massachusetts. That is or was a base, was it?
It is.
Thank you, Mr. Chairman. Hanscom is, but we're on the south side of Boston. Similar in name. Thank you very much, Mr. Chairman, members of the committee. My name is Erin Hearn, and I work alongside Unchained at Last as a volunteer. Maintaining New Hampshire's ban on child marriage is not about maturity. We know that turning 18 does not suddenly endow someone with newfound wisdom. However, as mentioned previously, on their 18th birthday, individuals do gain all the rights of adulthood that they did not have the day before. This is especially important in cases where a minor might be forced into marriage. A minor being forced to marry a service member can't simply open the door and run away to avoid that forced marriage. A minor who runs away from home repeatedly can be deemed a child in need of services and summoned to a court hearing to determine further intervention. Even if they could run away, there's nowhere for them to go. Advocates who provide direct services to these minors have found that domestic violence shelters across the U.S. routinely turn away unaccompanied minors, even emancipated minors. Youth shelters are also not a solution, as they're not confidential and typically only allow a 21-day stay, as their main goal is to reunite the minors with their parents, who may have been the ones to force them into this child marriage. While an adult in this situation could retain an attorney to help them figure out their complex legal needs, a minor cannot because contracts with minors are voidable. Minors are not even allowed to bring legal action independently. As you've heard, minors are automatically emancipated upon marriage, gaining limited adult rights. However, these rights do not prevent forced marriages, which can typically mean being removed from school and raped on her wedding night. The trauma of such experiences cannot be erased by granting emancipation. That is why all child marriage is globally recognized as forced marriage, because minors lack the necessary legal rights to enter a contract as serious as marriage. When girls facing forced marriages seek help from direct service providers like Unchained at Last, they often discover their legal options are very limited. Their desperation can sometimes lead to self-harm or even attempted suicide, as they see no other way to escape what feels like an unbearable situation. For these reasons, I ask that you oppose HB 433, and I thank you very much for your time and consideration.
Thank you for your testimony. Do we have any questions? Thank you for coming. Chair recognizes that he has elderly eyes and may not get the first name right. So it is Ms. Rice, and you can fill me in on that first name, please.
The first name is Frady, but it's a misnomer because I'm not afraid. Frady, like a Frady cat without the cat.
You have come all the way from Westfield, New Jersey for today.
I have.
Thank you for coming.
Thank you. So I'm here as a survivor. I'm a forced marriage survivor, so this is very personal for me. I'm here as an advocate for my traumatic experience. I founded Unchained at Last to end forced and child marriage in the U.S., including here in New Hampshire. And I'm here as an expert. My research and writing on this issue have been published extensively. I urge you to vote no on HB 433. Let's not undo the progress we made last year when we ended child marriage in New Hampshire. First of all, child marriage in a military context is dangerous. We at Unchained have worked with many survivors who were forced as minors to marry service members. At age 17, forced to marry a service member. Why should a girl in that situation get any less protection than a girl being forced to marry a civilian? I can't think of any reason. Child marriage is associated with high rates of domestic violence, and you heard a little bit here from firsthand accounts and others how hard it is to get help in a domestic violence situation in the military. So not only is it the police situation and reporting it, but also think about the fact that military spouses can be alienated from their family and friends because they move frequently. And so it becomes very hard for them to develop that circle of trust that they need to get help in a domestic violence situation. And you heard here before somebody testify child marriage works. 70 to 80% divorce rate. Child marriage does not work. It's unlikely this is going to work out. Highly likely that this girl is going to need help and not be able to get it on a military base. Now, and you also heard how hard it is to serve a service member. So if this girl wants to get divorced, how trapped she can become, even though she's technically emancipated and has the rights of adulthood. Now, child marriage in the military context also is unnecessary. You heard about that heartbreaking situation. A girl is not married to her boyfriend who deploys, and he dies in service to this country, and now she's left destitute. You can assign your death benefits and your life insurance in the military to anyone you want, regardless of your marital status. You don't have to marry for that reason. And for a 17-year-old who needs health and housing resources, we should never, ever write legislation that encourages or requires girls in that terrible situation to marry service members so that they can get these resources. They deserve and can get resources that do not require them to enter into an adult sexual relationship with lifelong repercussions. And of course, the service members' benefits would extend to their children regardless of their marital status. Now, bringing back marriage at age 17, even if it's only the slight little exception for military, also would bring back the legal trafficking of minors under the guise of marriage. And that's because federal law doesn't specify a minimum age for marriage. Instead, it defers to state law. And so that means 17-year-olds in the state would again be allowed to be trafficked for their citizenship.
15 seconds left.
In my last 15 seconds, I will say you heard about Alaska having a military exception to the marriage age. That is a law that was written in 1975 and has not been updated. Other than Alaska, we don't know of a single state in the entire world with a military exception to the marriage age. The Dark Ages have called. They want the...
Thank you for your testimony. I gave you several seconds more. You're welcome. In New Jersey, it was a long trip. Any questions? I've been to New Jersey. Yeah. Any question? Okay. We will be executing this bill sometime in the future, but not today. This ends the hearing on House Bill 433. Please be back at 1 o'clock, and we'll have some more fun. Thank you. Open the hearing on House Bill 478, establishing a foster care oversight committee within the Oversight Commission on Children's Services. Flown in at great expense from his normal seat up here is the pride of Milford, New Hampshire, Representative Bishop Petrino.
Thank you, Mr. Chairman, and thank you, my colleagues on Children and Family Law. So I present House Bill 478 to establish a permanent foster care oversight subcommittee within the Oversight Commission on Children's Services. Now, this legislation originated from a bill we had last year that sailed through this committee nicely and throughout the process, and that was Senate Bill 566. And that formed a study foster care families, and we had some members, Representative DeSimone, Representative Alicia Gregg, and myself, along with Senator Shannon Shandley. And we met over the summer from August through October. We held 8 meetings, and at which time we heard testimony from DCYF. We heard testimonies from the Office of the Child Advocate, various children advocates, such as the Children's Law Center and Waypoint. We met with and interviewed and heard testimony from current and former foster parents. And what we heard was that a lot of foster parents are feeling isolated. They're feeling lonely. They're feeling that the children's needs are not being met. A lot feel that they have a lack of support. They reported dysfunction within the agency, problems with the courts. And so we heard the testimony. We took it very seriously. In fact, the senator and I even met with some Milford constituents in a coffee shop because they were unable to attend, and we heard their testimony as well. So the bottom line is, after a lot of work that we did over the summer, it was recommended that we put forth this bill so that we can continue to hear the needs of foster parents and also to maintain oversight over DCYF in this regard. So with that, I'll entertain any questions. Thank you very much.
Seeing none,
Thank you.
come on back. Chair recognizes Lissa Marcio and Cassandra Sanchez from OCA.
Good afternoon. Hello. It's been a long time. Nice to see you all. For the record, Cassandra Sanchez, child advocate for the state of New Hampshire.
And I am Lissa Mascio, Associate Child Advocate. I thought we knew each other better, sir, with my name. Lissa Mascio.
I don't normally
Is my handwriting that bad?
greet you by looking at your foreheads.
I know. Trying to protect you all. We
Appreciate
are
that.
here on to support this bill. I did attend most of the sessions this summer with Representative DeSimone and Representative Petrino and Representative Gregg. Oh, she's not there. Okay. I was like, where is she? And we had also reached out in our networks and had met with a bunch of foster parent groups. They meet kind of informally. There's Facebook groups, and we had reached out to them via Facebook to invite them. So we also got a lot of feedback. Not everyone could make it to the committee, but that there was a lot of discourse that they would like to be having. So we do feel like this would be nice to create this space within the Oversight Commission on Children's Services, specifically because that body already hears a lot of these same issues, but from a more systemic level. So it would be really nice to create this space for foster parents specifically to be able to come and feel like they can share that with a group that is really dedicated to listening to these issues. So we just wanted to share that perspective from having attended this summer.
And I just want to add very briefly that we heard from those foster parents that they really appreciated the attention and the time. They were feeling a lack of support by the division. I recently have not heard that same level of concern, but I know at that time it was very heightened. There was a lot of needs that they had that weren't being met. And so having the space to be heard made them feel valued in their role and want to continue. And retention of our foster parents is critical to the safety and well-being of our children. And so we want to support that however possible. Thank you.
Any questions for the good folks from OCA? Seeing none, mask up, and thank you very much.
Thank you.
Now, let's see who I can recognize by foreheads here. Chair recognizes Susan Larrabee and Jennifer Ross from DCYF. There you are. All right. Halfway through, you have to swap.
Okay, good.
Okay.
Or we could share a seat too. Good afternoon, Susan Larrabee, General Counsel and Legislative Liaison for DCYF.
Good afternoon, Jennifer Ross, Deputy Director for DCYF.
We really don't have any testimony to provide today. We are not in opposition to this bill. As many know in this room, we have worked tirelessly to improve, especially this over the summer, going to these meetings, hearing from the foster parents what they need. Because it's not only about about recruiting these foster parents, especially now with kinship care and recruiting these special kinship care homes, but retaining them, working with them to make them feel supported. So we have no opposition to having a community oversight of helping us, working with us, and problem solving and working to the good of recruiting and retaining these very special pieces of this complicated puzzle.
Would it be your opinion that the quality work done by this subcommittee would be akin to the quality work done by the subcommittees for me, who chair DHHS oversight, that oversight subcommittees are a good thing? Would that be your testimony?
That would be my testimony.
I was hoping so.
Yes. Great.
Yes, I agree.
Oh, anything else you want to give us?
No, and
We
we're
are
happy to answer
ahead
any
of
questions.
time, even though we got a late lunch. So any questions for the folks from DHHS? No?
Great. Thank you.
Just remember, we've moved DHHS oversight to 1 p.m. And it will be the third Friday of February because the fourth Friday is New Hampshire school vacation. So if you have any business before my oversight committee, it's 1 p.m. on the third Friday of February.
Great.
Okay?
Thank you.
Good. Okay, thank you so much. I have no other cards on 478. So I close the hearing, and I'm willing to bet that my ranking member will have no objection to move to oversight. You see, no objection. I open the executive session on House Bill 478, establishing a foster care oversight committee within the Oversight Commission on Children's Services. And I am going to call on Representative Petrino for a motion.
Thank you, Mr. Chairman. I move ought to pass on House Bill 478.
And I will second it. Now, any further discussion during our time together on this? Everybody looks so happy. Well, in fact, even one of our happy members is ecstatic with joy.
She wants me.
Why, that would be Representative Gregg.
Thank you, Mr. Chairman. I really think that this, is it a commission, committee, whatever, that we're establishing is very important. I sat on the foster care special committee over the summer, and it felt like that bowl of pasta, the more we dug into it, the more there was. And so it's certainly a challenging thing, but a very, very important thing. So I'm happy to support this.
Representative DeSimone.
Thank you, Mr. Chair. Although I echo both Representative Petrino and Representative Gregg's sentiments, I also want to say that I'll use a different analogy. There are so many layers to the foster care program, and we've added 2 more layers with the kinship and fictive care, that I think that this type of a subcommittee on that commission is absolutely necessary for us to be able to learn and help the department learn what good we can do with these foster care programs. I was in a meeting yesterday, and we were talking about the need for more foster families to keep kids out of placement in particular facilities. So if we're going to keep the kids out of those facilities and put them in loving, caring homes, I think this will do it. Thank you, Mr. Chair.
Yes, Representative Malone.
So I have been a foster mom as well as a kinship provider here in New Hampshire for 25 years. Anything that we can do to promote the strength and the support that foster families get is just going to strengthen the system. Most foster families, they're trying really hard to reunite these children with their families, which means they have to have training on trauma that comes from these families, being able to not hold a grudge against bio families when you see some of the reports that come through, and it's not easy. Your children also go through this vicarious trauma that the other children have come into your house. So again, whether they're related, and I've done both. I just had my last one just aged out. She's going to be with us until she's 20 because she took the aftercare that's provided. 25 years ago, we barely had any support as foster families, and we even stopped doing it for a while because it felt like you did not know where you belong. So I think this is incredible.
My point earlier, oversight committees, I think, have a lot of great value because you bring people with various aspects of the subject together in the same room, and there's a lot of cross-fertilization. What is lost, however, sometimes is so many of us have become generalists. A specific subject doesn't get dealt with to the depth it is needed. And I think by having a subcommittee under this oversight committee, you have the advantage of both a large synthetic way of looking at things, but also going deep into specific things. And I found in my oversight committee, which is DHHS, this to be the case. Seeing no further comments, the bill before us is House Bill 478, establishing a foster care oversight committee within the Oversight Commission on Children's Services, moved by Representative Petrino, seconded by Representative M. Pearson. And would the clerk please call the roll?
Chairman Pearson?
Yes.
Representative DeSimone?
Yes.
Representative Rice?
Yes.
Representative McMahon?
Yes.
Representative Nelson?
Yes.
Representative Seidel?
Yes.
Representative Love?
Yes.
Representative Corzine? Yes. Representative Markle?
Yes.
Representative Petrino?
Yes.
Representative Grossman?
Yes.
Representative Levesque? Representative Gregg?
Yes.
Representative Raymond? Representative Georges?
Yes.
Representative Malone?
Yes.
15 to 1.
No, it is not.
15 to none, sorry.
15 to none with one absence. And I've got a great idea. We could put this one on consent. Any objections? No objections. So on to consent it goes. And Representative Petrino, if you haven't already written your report on this, please do so and pass it along before you leave tonight. We have our next, that closes the executive session on 478. Our next up is 553, and we must wait exactly 6 minutes before we start. As often is the case, and I have one of these tomorrow, the bill that we have all looked at is often replaced in whole or part by an amendment. And that's important because sometimes the things we didn't like in a particular bill, the amendment has taken out. So I would suggest in the 5.5 minutes we have left, you should have in front of you 2025-0114H, Amendment to Bill 553. And I would suggest you read it over. Representative Gregg, who will be introducing the bill, will speak to this when it is her turn to. But in the meantime, let's read it over. Wow, look at him. And just while you're reading it over and not chatting amongst yourselves, this amendment only replaces one section of it. So note that this is not a replace all amendment. No, it's not. I open the hearing on House Bill 553, an act relative to the definition of abuse and neglect and conditions triggering a rebuttable presumption of harm in abuse and neglect cases, with the prime sponsor, our very own Representative Gregg.
Thank you, Chairman Pearson, and thank you, fellow committee members. For the record, my name is Alicia Gregg. I represent Nashua Ward 7. I'm proud to be here before you today. I would first like to point to the amendment that we have here, which is 2025-0114H. Unfortunately, when OLS had the bill, apparently there were some miscommunications and came out with some things that not only myself, but also the stakeholders that we talked to and the original committee that worked on this did not agree to. So this is just taking that back to the original language that was agreed upon. This particular bill comes from a study committee headed by Senator Carson and also former Senator Whitley. It had actually our own Representative McMahon on it as well. They worked very hard this last year in trying to figure out what we could do to update our definitions of child abuse and neglect. And that's where this language comes from, with a little bit more refinement afterwards. There are a few things that can bring people together, like the protection of children. What we are gathered here today to discuss is that very topic. When we first looked at this bill, when I first got this bill, there was some discussion amongst people. Do we name this bill? Do we name it after some of our most tragic cases that have been in the news? Certainly not the most tragic overall, but the ones that we hear about. Javion Riley, Brielle Gage, Boo Vaughn, Elijah Lewis, Harmony Montgomery, or any of our broken babies. The list of possibilities is far too long. Ultimately, we decided that this bill, once it gets amended and refined, belongs to all kids in the Granite State. I've sat with many of you on different committees, the committee looking at DCYF, the committee looking at family courts and foster care. One thing that is glaringly important is that something is missing. Far too many kids are ending up incredibly hurt. So when we look at our bills that we have before this committee, 169C I like to refer to as kind of our holy grail. It's the Child Protection Act. Anytime we want to open that up and look at it, it's a big deal, and it has to come with the highest level of attention. And that's what's happened. For 45 years, this has sat with not a good or robust revision on what defines abuse and neglect in our state. While we continue to make attempts to band-aid or correct what we already have, we have yet to go back to this foundational piece. It's kind of like if you have a foundation of a house that continues to crumble and you just put new siding on. It's never actually going to work. That siding's going to pop off. Everything's going to be unstable. We have to go back to the foundation, and that's something that until this, we haven't done it. Now, this was attempted last year. I believe it was Senate Bill 459. We had these definitions. A lot of this language is very similar, with one big change. It had a very large fiscal note on it. This one, while it does have a fiscal note still listed, will have no fiscal note. This has no cost, which is great on this slim budget year. Now, I look back because I thought 45 years, first of all, I was a little shocked that 1980 was 45 years ago. So I had to double check myself, but believe it or not, it was. And I was definitely old enough. And if you're my age or close to, you might remember when you could ride on the middle hump in the car, or I even rode in my grandma's back window. And that was okay then. We knew that it was okay. And this is 1980. This is when this language was first devised. But the thing is, when we know better, we do better. We've had a lot of advancements. We've had a lot more learning about what happens with kids. So after I got this language from Senator Carson, it was incredibly important for me to go to the stakeholders that had been a part of those conversations one by one and say, what is your input on this? Let's hear it. Hours and hours and hours this last fall. Actually, I think this is so important. I waited to give it to my co-sponsors until I had a more refined language from the people that work in this day in and day out. Now, we have a really exceptional position here in the Children and Family Law because we get to hear from all of these stakeholders. So while one particular group might be very focused on one area of the law, it's our job to look at all focuses and not just to say, well, we want to make sure we hone this in on one thing and not the others. What the Child Protection Act does is it says the kids. This is about child protection. This bill is a civil bill because it's a civil matter. This is just about definitions of child abuse and neglect. This is not prosecutory. This is not about the criminal side of it. That's something different. This is just about the definitions. And I understand that it's challenging for somebody to come in and question our parenting. There's nothing more personal than your parenting style. There just isn't. That doesn't mean that what we're doing is always right. I have my own personal experience in having my parenting questioned. And while it wasn't easy, I understood the necessity because I wanted the safety of my children. For those of you that don't know, I'm a domestic violence survivor. I also spend my time talking to groups about what domestic violence is, breaking down those stigmas and really saying, what is it? Because believe it or not, I lived in it for 18 years and didn't realize that it was a domestic violent relationship. I just thought he was a jerk. And that I probably needed to do a lot better, that I was getting punishment because I wasn't worthy. Took me 18 years to figure that out. I never thought about the flip side of that. I specialized in helping other victims and stuff until one time I was talking to a school, a trade school, about what domestic violence looks like. And I had somebody come up to me after and they said, so I think I'm an abuser. Could you please talk to me? And it's at that point I realized, and in talking to her, understanding that even though some people don't realize they're being controlled or whatever, sometimes we're making decisions based on how we were raised, based on, anything hereditary, and we don't understand that we're making complicating decisions for our children. Now we understand, and we've had trauma-informed care, we heard earlier about ACE scores. We understand how different childhood factors affect our futures. And that's why our committee is so important, and what we do on this bill is so important because it shapes the future of our community. The children that we have that we can protect today are the children that will be our future doctors, our future scientists, our future sanitation workers, our future nurses. There's no end to that. They are our future, and their protection is of the utmost importance. Now, legislatively, we have all agreed that the home is the best place to keep kids. This is also not about removing children from the home. This is about figuring out how to get services before we have crisis. There have been so many testimonies. I have looked at the DCYF workers in the eye and questioned them quite fiercely about why they're missing some certain areas. Well, when you look, remember we talked about that root part of it, right? That foundation. When you look at the standard that they are held to currently, we're holding them to a standard without them having the tools in their toolbox to be able to do something. A major crisis has to almost happen before they can really do anything. And they're not coming in to arrest people and further do that. They're trying to get services to people because I guarantee you there are parents that don't understand that even though their father and their grandfather or their mother and their grandmother did things, that's not the best practice now. There are better ways to do it. We also have a generation of kids that maybe have access and understanding to things that we did not have. And so sometimes it takes somebody to come in and help us with that. This is about helping Granite State families to remain a family, to raise children in a healthy manner that will help them. Parenting is one of the most important things we can do. I actually believe that our children are on loan to us and that our job is to guide them, to get them to that next step. The Child Protection Act is an incredibly important piece of legislation, and amending this and updating the language to fit today's needs is imperative. We cannot continue to let our children fall through the cracks of a crumbling foundation. It is time for us to take this foundation, build it, so then we can build off of that. But we need to have these definitions updated. Will this fix all of it? Oh no. It's going to be that bowl of pasta I talked about earlier, and there's going to be more, but at least we have a solid foundation to start with. There are experts here that are going to talk really specifically about each piece of the language in this. I'm happy to answer any questions, but I think when it comes to specific, I will let them handle it because they're in the trenches working this while we're still kind of like observing all of it. So thank you.
Questions for the representative? Representative Raymond.
Thank you, Mr. Chairman. My question is actually for you, sir. Can we ask about the amendment at this time or only the underlying bill?
The chair makes the ruling that you may ask about the amendment.
Thank you. Can you speak to what the amendment changes from the original and why it's important?
Well, originally, the language that we had, and I kind of touched on that earlier, was a particular way. And let me see. Let me get this out here. There were some specific things left out, and specifically that we left out that were added. And I think that the Office of the Child Advocate would actually be better to explain this. But I do know that there was one part that continued to flag that actually, I believe she's here today, Representative Beauchemin called me and said, this says in utero. And I'm like, I don't remember in utero anywhere in there. And then I went back and looked to see what OLS gave me, and magically those 2 words were in there. So that's something that we did take out. There's some complicating things. Commas are everything. You'll see that there are some commas changed because it completely changes the meaning of that. But I think that the OCA will be better equipped to answer all of those questions because they're pretty, they're technical, but it changes the entire thing.
Thank you. Thank you, Mr. Chairman. I'll wait for OCS then.
Okay. Representative Love.
Thank you, Mr. Chair. Thank you for taking my questions. In multiple places here, we are using the terms emotional and psychological abuse and stuff and that. How is that measured?
I think that would better be explained by some experts, but I do know from my own personal experience with emotional and psychological, that's not disagreeing with your kids. That's certainly, we do disagree with our kids. We're allowed to disagree with our kids, even though my teenager would like to think differently. It's about whenever it goes beyond that and it goes to belittling, it goes to damaging behavior. And so there are certainly a lot of studies and stuff. And I know that DCYF and OCA can probably talk, and there might even be a couple of doctors that can talk more to that.
Follow up?
Mr. Chair, I have multiple questions on this. Would it be all right if I?
Let's do a few of them, the most important ones.
Okay. Let's see. Where am I?
Are we talking about the amendment or the bill?
Both.
Okay.
Okay. We use the terms preponderance of the evidence standard rather than beyond a reasonable doubt. Beyond a reasonable doubt's been the standard that courts have used for forever.
So not in, as far as I understand, not in civil cases. In criminal, yes, there is a difference within civil cases. Abuse can be very hard to define, and certainly it's not always as clear cut. For every person that I've talked to that has been a survivor of domestic violence, their counterpart has also claimed abuse. So it's one of those things that you're not going to have that level of care. And if we waited for that level of care, we'd have a lot more in the situation that the kiddos that I listed.
I would like to ask for a comment from Attorney Markell, one of our representatives, as a definition of preponderance, a one-sentence definition. Is it more than 50% of the evidence?
Yes. The preponderance of the evidence standard is simply more likely than not. Get the ball over the net.
Thank you. You know, the judiciary wants me to go to law school, you know? Yeah, okay.
We've heard that.
Representative Love.
I'll let somebody else ask, and I'll find the other things.
That's good. Okay. Anyone else? Have you found one of them? Can you wing it?
Yes, I have.
Good.
Right at the very beginning of the amendment, it talks about abandonment of the child. For how long? What are the age structures for this? You know, it's different to leave a 2-year-old than it is a 12-year-old. Letting the 12-year-old go play ball down behind the school shouldn't be abandonment. And the way this is written, it certainly could be.
Well, absolutely. And I think that I will once again refer to the OCA too. That's a very specific language piece that was worked on by Senator Carson and that committee along with them. So I'll let the OCA answer that.
Thank you.
Anything else for Representative Gregg? Seeing nothing, come on back. Chair recognizes Brian Fleming, police officer from where? Okay, thank you.
Sorry, from Manchester. Good afternoon, and thank you for allowing me to speak today in support of this bill. My name is Sergeant Brian Fleming. I'm with the Manchester Police Department. I'm the sergeant in the juvenile unit, and we handle the cases of child abuse, neglect, and among other cases. For the past 7 of my 19-year career, I've been handling juvenile related cases, and I believe anything that will further the safety of children and anything that we can do as a state is a benefit. I just prepared some notes here. The bill takes important steps to address the complex issues of child abuse and neglect by expanding the definitions to include crucial aspects of a child's well-being, such as emotional and psychological harm. Previously, these often invisible forms of abuse were difficult to address within the legal framework, but this bill ensures these children will receive the same protection as those that are suffering from physical abuse, because oftentimes you can see the physical abuse, obviously, but you might not know or be able to see necessarily psychological and emotional abuse. I also believe this bill will help to give DCYF the ability to get services into place earlier to hopefully prevent anything from ever reaching the criminal level where police involvement becomes necessary. I totally agree with the statements that were just previously said as far as keeping the family together, trying to support the family as best as we can. And we would rather see, as a police department, the services that are available out there through DCYF and other agencies help the families prior to it reaching a police level or criminal investigation. So anything that we can do to get early intervention into these families, with these children, to prevent anybody from getting in trouble criminally, we fully support. The introduction of the rebutable presumption of harm is another significant improvement. This provision recognizes the inherent danger to children when they are exposed to parental substance misuse, impaired driving, domestic violence in the home, or oftentimes a serious unexplained injury of a young child or infant. By shifting the burden to the responsible party to demonstrate the child's safety is not compromised, we or the other agencies out there can intervene earlier and potentially prevent any further harm to the child. This bill also enlists a trauma-informed approach throughout the child protection system, while emphasizing that the primary determinant in these cases is the safety, welfare, and best interest of the child. This means doing whatever is necessary to keep the kids safe and recognizing the profound impact of trauma on children and responding in ways to help promote their healing and resilience, because the ultimate goal is to make sure these children feel safe and that they can grow up feeling safe and become productive members of society and be able to work through whatever trauma they've had to endure throughout their young lives. This bill also provides DCYF with clearer definitions, stronger legal backing, and a mandate for the trauma-informed care, ultimately leading to more effective interventions and support for children and families. Adding the specific language that's in there, including the psychological and emotional abuse, beyond just the term safety, allows us to be more clear as to what the child can be protected under. In my experiences, I've encountered numerous cases where earlier intervention and a more comprehensive understanding of the abuse and neglect could have made a significant difference in the child's life, but steps weren't taken prior due to nothing being in place to possibly protect that child. This bill provides the necessary framework to prevent serious crimes and ensures that all children have the opportunity to thrive.
Is it officer or?
Sergeant.
Sergeant, thank you for coming. while we can imagine cases where intervention did not happen in a timely way, can you speak to the frequency of when sincere but misguided intervention took place? In other words, the family was put into a situation because of a complaint that was not warranted, and there was harm done. Could you speak to that one, Sergeant?
I just want to make sure I have the question. Where services were put into place, but they weren't necessarily needed due to the.
No, I mean aggressive intervention in a family that was wrong to have happened.
I don't necessarily know if I could speak to that specific as far as like the in-home services and that sort of stuff.
What I'm trying to say
Yeah.
is have agents come in like gangbusters into a family and uprooted and made everybody cry, and come to find out they never should have done that. Have you experiences of that secondhand?
I personally have not. I can't say that it's never happened. That because I wouldn't know offhand, but I have never been involved with a situation such as that.
So is it true to say that that scenario is significantly dwarfed to the scenario of intervention should have been done, but it wasn't?
In my opinion, yes.
Thank you. Any other questions for the sergeant? Okay, seeing none, thank you, and thank you for your service, Sergeant.
Thank you for allowing me to speak today.
Mr. Chairman, I do have one. I'm sorry.
Okay, he hadn't left yet, so go for it.
No, I saw him start to get up, and then it occurred to me. Thank you for indulging me, and thank you for sitting back down. Have there been cases where the police were able to act before DCYF that you've experienced?
Yes. Without getting into specifics, we have responded to a call prior to DCYF, or it came in through the police department, and we've encountered situations where we've had to take the children, but then obviously we immediately call DCYF and they respond. So there has been times where we've gone out and acted prior to DCYF being notified.
Okay, follow up for clarification.
Follow up.
Have you had any cases where the police have felt that a family needs intervention to protect children who were at risk of harm, where DCYF was unable to enact an intervention because of the way the current definitions work?
I don't believe so. I mean, we've safety planned children, but we've always reached out to DCYF to get guidance and they're very quick to respond with us. So if we've had to intervene like that, they're always either responding or following up the next day.
Okay.
Or they're a part of the safety plan that we're enacting, because we typically let them know if we're removing a child or anything like that.
Okay, thank you.
Last call. Thank you, Sergeant.
Thank you.
Here's what I'm going to do. There were numbers of technical questions asked of the bill's prime sponsor, and she said that she would defer to some people who could give technical answers. I'm going to call on those people first. Then I'm going to call on any active state representatives we have. That is usual protocol. And then I'm going to deal with a whole stack of pink cards. I'm going to tell you ahead of time, anybody at that point will have 4 minutes to testify. And as I said at a previous hearing, you can get a lot in 4 minutes. So if you have a script, you may want to cut out some things that is unnecessary verbiage. The best speech I ever heard in this committee was 47 seconds long. It was on point. It made the points well. It answered a possible objection. 47 seconds. We paid attention. I'm not saying that anybody in this room starts losing interest in the middle of a long speech, because I don't think I have to say that. So if you have something prepared, I want to hear it. But it's going to be 4 minutes. So with that in mind, I'd first like to call up to provide answers to technical questions that we've had, Cassandra Sanchez and Attorney Lissa Masio from OCA.
Good afternoon once again, and for the record, Cassandra Sanchez, child advocate for the state of New Hampshire.
And your faithful sidekick,
And
attorney
with me,
Lisa Masio.
Lisa Masio, the Associate Child Advocate. We do have written testimony that we are sharing with you today. I will not drown on and on about that. But I do want to share in immediate response to some of the questions asked, in particular the first question from Representative Raymond. Yes, we have seen cases in which DCYF was unable to act when they wanted to. We did some work with the field administrators at DCYF a little over a year ago, and they sent us over 30 case examples where they filed in court and the judge did not uphold their finding. Therefore, they were unable to continue to service that family and work with that family when they truly felt those children were in danger. We learned of these concerns because the field in DCYF came to the Office of the Child Advocate and asked for our help and said, we don't know what to do. We are really worried about these children, but the courts are saying we don't have enough. How can we protect these children? They do offer voluntary cases, which they did in these instances. In the majority of those cases, the families did not choose to take because they did not want to work with the agency. I think it's very important to highlight what Representative Gregg had shared with us, that oftentimes many families aren't ready or aren't even aware that the behaviors that are happening in the home are unsafe to their children. And so if there's no willingness to take a service, how do we help them learn and grow so that something detrimental does not happen down the line that truly will tear that family apart? As mentioned, it is very critical in all of this that we focus on maintaining families together, however, whenever possible. We as a state have put a lot of attention and effort into building out a children's system of care so that there are community-based services able to service families as opposed to children needing to be removed from the home to receive those services. We have a very well built out children's system of care. Of course, we need to continue to fund this because it is highly utilized right now in our state. But what that tells us is that our families are benefiting from what has been built, but there are still families who are slipping through the cracks. And that is what we are hoping that this change in language will catch. This is not to bring in new families involved with the division, but this is to service the very families that they are already involved with. They are already receiving calls about. They are already assessing these families. Oftentimes, time and time again, because they may not have enough the first time, and a couple of months later, they get another call. A couple of months later, another call may come in. It may be a year, but then there is another call. These are not new families. These are repeat families that truly do need assistance and help, but again, may not be aware of how to do that. And oftentimes aren't aware of what is out there in the community to seek it out on their own. So they need guidance from a professional to show them what can help their family and where they can be down the road if they do take that help. It's also important to acknowledge in this bill, as was said quite a bit, it is 45 years old. There has been a lot of psychological research that has happened in that time frame. A large focus on ACEs, if anybody's familiar with this, adverse childhood experiences. What we learn from adverse childhood experiences, the more of them that a child has exposure to, the more likelihood they have of future health issues down the road. So we're not just talking about mental health concerns down the road, although that is absolutely a component of this, but we're talking about physical health outcomes that are negative, and scientific research told us that, but we didn't necessarily have enough information then. There was a lot more work done around trauma and understanding how trauma impacts people throughout their lifespan, how trauma that happens as a young child doesn't just live in your childhood. It follows you through the trajectory of the rest of your life and has a great impact on what you can do in the future. And by bringing this statute into the current day and time, to the psychological research that really touches on the importance of psychological impact and trauma to children, we can hopefully prevent some of this. And truly that is the key. It is prevention work that it's going to take to reduce these negative outcomes. We need to get into families early on, as we heard the sergeant just share. It's really important to have that early intervention. And by allowing the division to file petitions based on psychological abuse, get into a household, teach those parents, educate them, hopefully that's a one-time occurrence that they need to touch that system and they will never come back again because they've learned from that. But if we don't allow that opportunity, these families do come back and back until something terrible happens. And it's, again, this is for the entire family unit. The abuse of a child impacts everybody around them. particularly their parents that we know care deeply about them and want to see positive outcomes. Yes, there are some very horrific cases we've seen with parents who did not have great intentions for their children, but we know that is not most parents. And we know most parents are truly fighting to provide all that they can for their children, but we live in a very complex world right now. Tensions are high generally for adults, and so that complicates life for children as well. We are seeing children with higher rates of mental health diagnoses. We are seeing children with higher rates of suicide. Suicide right now is the number 2 cause of death in children 10 to 14 years old. That is extremely young. We need our children. They are our next generation. And so it is important that we added in as well the definition of trauma-informed care, because what that means is it's a system that's paying attention to the trauma, aware of it, and responding to people that way. Many parents who are touching the system have also had their own trauma. We know generational trauma is what leads many families into this system. And so having trauma-informed care at the heart of the work that the agency does, but now when they're intervening and working with the family, they're not just looking at the family and pointing a finger and saying, parent, you're doing something wrong. They're saying, we know you've been through something. Let's figure out how to get your entire family unit to a better place. And so we did work very, very hard to make sure that we found thorough trauma-informed definitions that came from psychologically backed resources such as the National Child Traumatic Stress Network and APSAC, which is the American Professional Society on the Abuse of Children, 2 very highly regarded national organizations, so that is where the definition in this bill came from. You may have heard us as well speak in this committee or in other committees in the past around a system review mapping that we had held in the summer of 2023. And this mapping was in regards to 9 non-ambulatory infants that presented to EDs with multiple broken bones over a 4-month period. That is a lot in a short amount of time. These children helped inform multiple sections throughout these revisions.
I just want to talk for a minute about the process of this bill. As you know, last session, Representative Gregg mentioned it was SB 459, which was Senator Carson's bill. We had worked on it for some time with the Oversight Commission on Children's Services. She had asked to retain it as a study committee because there were some discussions she wanted to have. So I did also pass around for your guys' information the study committee report, and attached to it is the language that Senator Carson put forth and provided to Representative Gregg as the language that that committee had arrived at. And Representative McMahon was on that committee. And that language has been agreed upon between the Office of Child Advocate, the Oversight Commission input, that committee's input, and DCYF, which was really important and was not quite as clear with SB 459. There had been some turnover in DCYF. So this was really a collaborative process. We sat at the table with Attorney Larrabee, with Deputy Ross, with Director Marie Noonan, and this language you have in front of you with the amendment, because there were some errors in the original bill that are corrected by the amendment. This is the agreed upon language. And if you read all of the minutes of the 8 meetings we had that were hours long each, many of these questions have been asked, and Representative McMahon asked many of them. They really went through this bill piece by piece and asked about every word. There were sometimes lengthy discussions about one word or one comma, of why things were worded that way. And those were discussions that were had with us, with other stakeholders in the room, with DCYF. Dr. Amy Roy, who you all may be familiar with, who have been here for a few years, is now actually the director of the CAP program at Dartmouth Hitchcock. Unfortunately, she's at a conference right now. Well, probably fortunately for her, she's in San Diego. So I just got off the phone with her, though, and she did sign in support. We worked directly with her quite heavily, especially around the non-ambulatory infant piece. Lieutenant Nicholas Georgiolis from Manchester, he sent his able sergeant here today. He's also at a conference. Also worked heavily with us. So Representative Love, I really appreciate your question, because this is a common misperception. 169C is a civil statute. The preponderance of the evidence has always been the standard in civil court. Beyond a reasonable doubt is only used in criminal proceedings. The amendment made in this bill is not a change to any law. It's just a clarification because the law was vague before. It just said insufficient evidence. What does that mean? So we added the correct standard of evidence in there because otherwise it was very vague and unclear. So a lot of the amendments made here were the culmination of conversations with many experts, with the experts at DCYF. But I can tell you that committee, the study committee with Senator Carson and Senator Whitley and Representative McMahon and Representative Robert Hard was also on it. They asked incredibly detailed questions. Another section I'd like to point you to that Representative Gregg alluded to is right at the beginning on page 1, line 20. An edit was made to presume that family unity is in the best interest of the child. It used to say to determine if preservation was. We know from research that preservation of the family unit is in the best interest. The purpose of this bill, and it really aligns well with SB 417 from last session, these were all presented at the same time, to maintain that family integrity. But as other folks have stated, without the proper tools in their belt, without clear, correct, thorough definitions, DCYF's hands are sometimes tied. And it does escalate to a point where the children do end up having to get removed because this is the 10th investigation. Now something really serious has happened. Whereas if we're able to see those interventions earlier, not after 5 or 10 assessments, you can preserve the family unit by putting services in place. So I can tell you that every word of this has probably been discussed at length, but we're here to answer those questions for you of what that process was like.
And to one more addition that I want to point you to before we open it up to questions, that you will see a very stark difference in the amendment and the bill as introduced. If you look under neglect in E, the as introduced talks about exposure of a child in utero, which was not the intended language there. And now that it has been fixed in the amendment, it speaks to a child who is born substance exposed. And what we found and our understanding and through the research as well is that it is really, really important to encourage mothers when they are pregnant to seek care, to seek all prenatal care that they can receive. And unfortunately, the way that it had previously been written, it was not clear that there are protections in place for mothers who are in treatment, who are taking medications to remain clean from illicit substances. And it's really important that we encourage them to do that. So we worked to put language in here that would ensure that when a parent, that it requires there to be more than just the substance exposure by the child, which means oftentimes a positive test at birth, rather than just a positive test at birth to have that family be involved with the agency. There also needs to be harm to the child. We do not want the hospitals to be calling on every single parent who is trying to do the right thing, who is trying to stay on their treatment plan. We want to make sure that there is truly a correlation between their use and harm to the child before the agency becomes involved. So that was a really important addition to us and a way to help protect mothers and ensure that they do seek out care throughout their pregnancy. We're now open to questions.
Questions? Representative Love.
Thank you, Mr. Chair. Thank you, ladies, for your testimony. I'd like some clarification on providing proper supervision. There's no language here for, once again, for age differences. It's different to leave a 2-year-old at the ballpark to play baseball than it is a 12-year-old. There's no language here for that. And I have a friend that was arrested for his 8-year-old granddaughter. He was sitting at the park with her and her brother, and the kids are running around. There's a bunch of them, and the 8-year-old girl went up and over the hill, and some kid found her. She got lost. She was less than 100 yards away, but he got arrested for that. Some kids started yelling and screaming and called the cops, and he got arrested and had to go to court and pay a lawyer and all that. And where is the definition of age-related requirements.
There is no age intentionally in this because developmental levels are drastically different for each child. So there could be a child who is 10 years old who's very self-sufficient. There could be a child who is 17 years old and is at the level of a 5-year-old developmentally. So by assigning an age to that, that could become quite dangerous actually, because oftentimes parents look at it like, well, if it says here the age, I'm going to follow that to a T. But if your 17-year-old truly is not safe to be home by themselves, then maybe we shouldn't be following that, or maybe we shouldn't even have that in there because it becomes a dangerous area in which we're holding the parents to something that the law actually contradicts. So it's really important to make sure we do not assign an age, but it is important for the agency to be very reasonable. And so it's important to know the process. What happens when somebody sees a child and they think they're in harm's way? They pick up the phone and they call DCYF and they get somebody on the other end of the phone from their central intake to take that report. That person on the other end of the phone who's taking in this information is also looking at what the abuse and neglect laws say. Oh, you got a 12-year-old, they're by the park by themselves. Mom was like in her car getting something and came back. That's not going to screen in as abuse and neglect to them. They're going to say, sorry, that's not us. We can guide you to community resources if you're worried about this family. We can guide the family to community resources, but that's not us. We are not going to investigate that. We are going to move on from that. And so it is important that there is that layer in between. It is not a call to DCYF and somebody is immediately knocking on your door. There is that in between of does this actually meet the statute to say whether that is something that they would open up. DCYF is in the room, so I would point to them to answer that question more specifically about, what they think about when they're assessing for that, for a child who's left home alone. I can say abandonment is quite different. Abandonment is truly a parent leaves and there is no parent there to care for the child, to sign school documents, to sign medical documents. They're not around. That is very different than a young child. Abandonment of even a 17-year-old is concerning because if that child has a medical issue and they need to seek care, there's no guardian to sign off for that. So abandonment is separate from that issue, but I do believe DCYF could speak better to when they would screen those out versus when they would not.
Follow up.
Is there any language that you could recommend to bridge the difference?
Right now, no, other than the language that we have here. I'm concerned about adding too much to the definitions here to really make it restrictive. It does need to be a bit more broad. And a lot of that additional work does come in DCYF updating policies after the fact as well. And so the OCA works very closely with them that whenever a bill is passed to ensure that the policy aligns with the intent of the bill. And the intent here is not to overstep in those instances.
I have a question for council.
Yes, sir.
It may be a caricature that whenever a bill dripping with compassion comes, people say, oh, that's a Democrat thing. Well, I can drip too, but that's not my point. Is it the case of the 4 committee members cited in this final report, 3 of them are Republicans?
That is the case, sir.
And would you believe I'm not doing that to toot our horn? I'm just trying to say that this is not a partisan issue. Would you agree?
Yes, and Senator Carson has frankly been one of the staunchest advocates and supporters of the Office of Child Advocate. She's chaired the Oversight Commission since its inception, and she has been pushing for this update. It was actually the committee that requested a definition of trauma-informed care and that vetted this current language. I actually believe it may have been Representative McMahon who requested it because we all say trauma-informed care as though everyone knows what that means. So that's where that definition came from, and it has been a very strongly bipartisan effort.
Thank you, Council, for taking my leading questions. Anything else? Yes, Representative Corzine.
Thank you, Mr. Chair. I'll get the
Chairman.
speaker soon.
Ma'am.
Thank you, Mr. Chairman.
Thank you.
Thank you for being here to answer my question. I have a lot of questions about this bill. But the one I want to raise now is in the neglect section, the one that you had just read, paragraph E. When the child is born alcohol or substance exposed, except when taking as prescribed or recommended and monitored by a licensed healthcare provider, and the newborn child's health or welfare is threatened by the use. So the way you had just explained it is you wouldn't step in unless the child's health was compromised because of the drug use in utero. But from what I understand, that's kind of luck of the draw. I've heard of situations where, you know, 2 pregnant women can do the same exact type of drug and you'll have one baby born that's perfectly fine. And then you'll have another baby who was born with all kinds of issues from the same exact drug use. So why are we automatically ruling one family out?
It's the importance of in these definitions, it requires serious impairment or harm to the child to be able to file abuse and neglect in the court to uphold that definition. And so realistically, it is different because where is the harm? The harm is not visible on infant A, who mom potentially had been using. The child did not exhibit any symptoms. Child B, who may have exhibited the symptoms, now we have harm. And so it is important if we just have these definitions that if you do this to your child, the agency can intervene. We're talking about pulling in a lot of families by the action. It's how did that action then directly harm the child? And so here we have made sure that there is a tie back to harm to the child, because it is true and it is very strange. We see these often actually, where we have cases that have been called into DCYF and one child has absolutely no response to the substance exposure and therefore they close out, but another family may not, and then they're servicing and working with that family.
Follow up?
Follow up.
So I'm really uncomfortable letting one parent off the hook because, you know, their little bodies took it in a different way than this little body, but both of those infants are still at risk.
Yes. And so when those risk factors are in place, the agency can offer a voluntary case to the family. They can offer them services to learn. Oftentimes we actually see a large response from the hospitals as well, sending home a VNA to continue to follow the child and make sure that they're thriving. And those are ones where typically if they do come back, they'd be coming back from a pediatrician or a daycare provider down the line. But again, it's really hard to tie it just to the actions of the parent because we'd have a lot more families involved in our system. And truly our child abuse and neglect statutes always tie back to how does that harm the child?
I have a question. My wife is a family practice physician and I've spent 50 years in part doing counseling. And she says it's much easier to measure physical problems than it is psychological problems. And she's right. And I suggested her for analysis. How would we measure psychological well-being?
It's quite difficult, to be frank. It is. I acknowledge that. But realistically, we see it start to impact different areas of a child's life often. So we're looking at how they interact with peers, how they interact around their family members, how they interact in a school setting, and are they struggling in different areas? And also a lot of children these days want to talk to people. And so we find that a lot of our children are either seeking out a therapist or maybe a school guidance counselor, and they're able to talk about their experiences and how it's impacting them. And that's how we learn so much about that impact of trauma, is through people sharing their experience. So when children open up and share that and they're telling somebody, I may be suicidal now because of things that have been going on in my home, that's going to flag for particularly school folks. If they're told in that setting, that's going to flag for that school folk that something is happening in that home. And we likely need to call it in and allow professionals to assess that. And then the professionals also then go meet and have a conversation with that child. They assess the whole family unit, but then they also separate that child and have a conversation with them one-on-one. And if the child's saying, I'm suffering with X, Y, and Z because of what's happening in my family unit, then we need to believe that to be true, and we need to believe that to be a psychological impact.
Would it be fair to say that there are certain behaviors that are consistent which doesn't prove it, but is consistent behavior to psychological abuse, and that various chapters in DSM and other places point us to what those behaviors are. Now, that's not 100% correspondence, but it is enough. Is it enough then to go forward with investigation?
Yes, because what are behaviors? They're another way the child communicates to us. Not all children have verbal communication. We need to read everything, nonverbal communication, behaviors. It's all a form of communication. So yes, there are some very specific behaviors that are tied to very serious issues such as psychological abuse. There are very specific, sexual abuse. There are very specific sexual reactive behaviors that can be seen from children that mirror child to child, can be somewhat different, but are pretty common to happen in children. And so that can tell us a lot. But there are other behaviors as well that, coupled with other information through an assessment, do tell us the child needs more.
Growing age regressive behaviors, for example?
Absolutely.
Yeah, okay. Counselor.
I just wanted to add from my experience, I was both a DCYF attorney, so kind of prosecuting abuse and neglect cases in the civil courts, as well as a parent attorney for quite some time. So the flip side of sort of expanding that language to include emotional, psychological, mental well-being is a call will often come in with concrete indicators. You know, a child is coming to school dirty, hungry, very tired. And when there is investigation, there might not be the physical indicators, as Sergeant Fleming mentioned, but there are a lot of psychological indicators or well-being indicators. That was sort of another gap that was being missed, that children are being exposed to trauma. They are in a neglectful situation, but the way the law was written 45 years ago, they weren't able to pursue and offer services to that family unless there was an indicator of their health or safety versus all these psychological indicators, which are often behavioral indicators. So it's also that flip side. It's not necessarily someone calling in of this child has a psychological indicator. It's more once you get in there, without that expansion of language to recognize all the impacts of trauma, it can sometimes be hard to pursue those cases, and they end up falling through the crack and have multiple assessments till things get really serious to a child potentially being suicidal.
Thank you. Representative Raymond.
Thank you, Mr. Chairman. Thank you for taking my question. One of the things that someone said a minute ago was about letting parents off the hook. And so I wanted to ask about, what does it mean to have services? Are we catching parents? Are we punishing parents? Like, what is the services? What's the purpose, and what's the array like?
Well, thank you. That's a great question. Really, the services that are being offered, the services that we as a state have come behind, are evidence-based services that show us that they have positive outcomes. And most of those evidence-based services truly rely on the family guiding the process. The family has to buy into that process. DCYF intervention is them coming to the house and checking in on the house and checking in, talking with family members, talking with the child. But the actual services that can be put into the home, like high fidelity wraparound services, it's really meeting with that family, hearing their story, telling them, how can we help you get to a better place? What are the goals we really want to see for your family? And then when that family determines that, they find others in the community to help build around that family to be their support system, whether it be natural supports or whether it be professional supports. And they're building that at the family's direction. Oftentimes it takes some time to get there, it takes some time to build that rapport, but they are coming in with that non-judgmental lens. It does feel more judgmental for families when DCYF is coming in and say, I have this allegation against you, let's talk about that. But when we're actually talking about the services that can come in to assist families, they may have that information, but they're not showing up at a family's door with a piece of paper that says, you did this to your child. They're showing up saying, we're here to help. How can we work together?
Follow up.
Thank you. And are families able to access those services without DCYF opening a case and paying for some of them?
There are few services that are accessible in the community without DCYF involvement. We are continuing to try to move there as a state, but initially the way our system was built out was for those services to be offered through DCYF. And so still to date, DCYF does have access to additional services, especially high intensity services. So for children who may really be struggling behaviorally, those services that can come to the house 3 or 4 times a week, those are primarily offered through DCYF at this time. And so there are still some families that don't necessarily want to become state involved, but they know their child's struggling and they will go to DCYF asking for help because they know that the services in the community cannot meet their level of need.
Thank you.
Representative Grossman.
Thank you, Chairman Pearson. Thank you, Office of the Child Advocate, for your always valued testimony. How does this, the amended version, how would it affect some of those babies that have come through ERs or with broken bones and gone home? Would this change the trajectory for some cases?
We strongly believe it would because of the addition of some language here. Find those sections. So page 3 on the bill as introduced, if you look at C there, it talks about physical injury to a child. And that really expanded on what we had prior. The important role there is the or indeterminate means if the parent, guardians, or custodians are the primary or sole caregivers and have offered no reasonable alternative explanations for said injuries. Unfortunately, in the many cases that we reviewed, there was no identified perpetrator. And therefore, when the division filed petitions, they were not successful in abuse petitions because they did not have that identified perpetrator. But what they did know at that time is they did know that the only caretakers for those children were their biological parents. And so something happened in that household between those two parents that harmed the child, but neither was willing to come forward and say that because then there's criminal implications for that parent. But what that then did was limit DCYF's ability to intervene and assist that family. So by this addition here, that is now, we don't need to have that identified perpetrator a perfect explanation as to what happened. We don't need to have that mapped out situation of, this is what they said and this is law enforcement's rebuild of the incident. They can say, we have not received enough information, and medical professionals can say, what was provided to us by parents is not what could have caused these injuries. We do not have further information, but we can say that is not a reasonable explanation. So with medical professionals being able to weigh in that way and then expanding it to include the indeterminate means, that would capture the majority of those children. The other addition is under serious impairment on page 8 in L. With the addition of any single incident or occurrence of serious injury or illness. That did not exist before. And the importance of a single incident is that with these babies, it was a single incident. There was, I believe, one that returned to the ED for a full skeletal that did have additional broken bones at that point that were identified, but all of the others, it was a single incident that led to it. And so we do not want to rely on old statute that requires multiple incidents to occur, because at that point, the child may not make it to that next medical visit. And then the final one is in the rebuttable presumption of harm on page 9. Evidence of serious injury, broken bones, or unexplained injuries to any non-ambulatory child. This did have an amendment to it because it had broken bones in the plural. And we wanted to ensure that one broken bone alone could be enough to show that a child is in harm's way. And so that is in the amendment. They provided some parentheses around the S, so it can be broken bone or broken bones. But those are all of the sections that do address those particular issues.
Thank you, OCA.
Thank you very much.
DCYF. Susan Larrabee, Jennifer Ross, come up. You want to answer questions and provide information. Okay, now you're swapping seats from last time. Okay, good. Thank you. Pay attention. Very good. And same thing. You are the ones that were behind the presenter. And are there additional explanations you might like to give us?
If I could just start by saying, again, good afternoon, Susan Larrabee, DCYF's General Counsel. I think what gets very hard sometimes when we look at bills and then amendment of bills, we're not looking at the complete chapter. And
Right.
here with 169C, it is a very complex and robust and wordy chapter. There are 40 subsections to this very important chapter, and there should be 40 subsections. But I think sometimes when that happens, we tend to only look at the bill itself and not how it fits into the already established act. So for instance, burden of proof that has come up a few times now. That has been in the statute, not just in civil actions alone, but in this specific statute, 169C13, burden of proof. The petitioner has the burden of proof to prove the allegations in support of the petition by a preponderance of the evidence. That's already in statute. This bill does not change that. This bill only changes two very specific sections, the definitions, but then the definitions applied throughout the act, as well as then the rebuttable presumptions of harm, which are not until the near the end of the act, because the rebuttable presumption of harm does not change the definitions of abuse and neglect. It is under the evidentiary section of the bill, of the act, to help us prove what is harm. What is serious impairment? What is risk of serious impairment? And that's very difficult to do, especially with psychological abuse. So I just want to put that into context. I think sometimes that's overlooked. Nothing in this bill changes the due process rights of parents. And that's why there are 40 sections of this bill that goes through every step of the process, from the initial call to central intake to the determination of whether or not that should be screened in for an investigation, for an assessment, while we are assessing and investigating whether or not that has been abused, whether or not there has been abuse or neglect. Remember, we are the Division 4 Children, Youth, and Families. Commonly, we're called Division of. And that little preposition, I think it's called a preposition in grammar, of and for are very important distinctions. We are for youth. We are for children. We're for families. It's not adversarial. Sometimes it may seem adversarial when it has to get to court. And we talked a little bit about those cases that have to go to court, that we have to prove the elements of abuse and neglect by a preponderance of the evidence. We're not changing that with this bill. We're not changing the due process rights of parents. We're trying, again, to enhance how we work with families. Deputy Director Ross can talk more about that if necessary. But again, we are working so hard towards that prevention step, working with them with voluntary services, providing the services that they need to become the parents that they want to become. So I just want to state that. And again, we're here to answer any questions you may have about this bill or any practices, policies, procedures that we have at DCYF.
Good afternoon, Jen Ross, Deputy Director, DCYF. I echo what Attorney Larrabee has to say, and we've talked about services to family. There are many ways that families can access services, and it doesn't always have to be a petition of abuse and neglect or us removing a child from their home to have services. We have voluntary services that we can, provide referrals for families to access within their communities. We do have our paid services that we can provide to families when we do become involved, but our ability to support families is only going to grow in this measure. I was the Child Protection Field Administrator that Office of Child Advocates Cassandra Sanchez and Attorney Masio were referring to when we started to talk about the children who were experiencing significant injuries, but yet were not receiving the services they needed, nor the families, to help understand how those injuries may have occurred, and then how to, support the family so those didn't happen again. So we do work collaboratively with each other to talk about how we can service families and children. And again, our job is to, ultimately protect the kids and ensure that their safety is protected while in their family unit and working with the family together. So again, happy to answer any practice questions, any additional questions you might have.
Is D of CYF full strength or short staffed?
We are always hiring, if anyone wants a job. We are at 78% capacity in our assessment area of practice, and we are at about 90% of capacity at our family service area of practice.
So is it fair to say that one of the reasons why sometimes something doesn't get the attention it deserves is your staff's already working full tilt and there's more cases, potential cases, than there are staff workers?
Yes, we have been fortunate over the past several years. The legislature has offered the ability for us to hire several new positions, particularly in our assessment phase, which is the initial phase of work with families, where we're investigating the allegations of abuse and neglect and making determinations. So we have been able to hire additional staff in that area of practice, which has helped with the outcomes that families are experiencing, but also the turnover for our staff. We are seeing an increased rise in case numbers because we are offering more voluntary services to families and working with families outside of court, but through an open case with the division. So we are seeing the case numbers, caseloads rise in that area. So we are looking at how to also support our family service workers as well.
Thank you.
Yep.
Questions? Representative Markell.
Thank you, Mr. Chairman, for taking my question. Thank you. What you're providing here, I think, is very valuable. We were earlier hearing talk about psychological harm. What provisions in this bill, or what provisions in the DCYF stable, if you will, allow for clinical assessment of psychological harm? And what do you see, for example, as the potential for diagnosis of psychological harm? And I'm going to also include in that the inherent risks associated with a differential diagnosis if this is going to be done without clinical assessment.
Yeah, so I can speak to the practice side. Our investigations are done with the family, and we also rely on information gathered from other sources. And so we are talking to, as the OCA had represented, we are talking with schools, we are talking with medical professionals, we are talking with mental health professionals and other individuals who might know the family and be working with the family at the same time. So our job is to gather as much information as we can about the child and the family and the situation to truly understand what might be happening. We do have access to evaluations, that we can provide parents and children and youth, both at the investigation phase as well as at the case phase. And so certainly understanding we do have a variety of providers that we work with that are informed of our practice, our system, trauma informed as well. And so we do work with multitude of different agencies to help with those evaluations and assessments to help us understand truly what might be happening.
Okay, so if you have
follow up,
I'm sorry.
Sure.
Thank you, Mr.
Sure.
Chairman, for a follow-up. Yeah, so for a follow-up, if any of these matters do end up in court for some reason, so in other words, you're saying that, if I hear you correctly, you have the actual expertise on staff. These people will be able to make those kinds of clinical assessments?
We do not have them on staff. We have them as providers that we contract with or certify to work with us, and we can provide families referrals to them, or we can use whatever community partner that the family might be comfortable using as well. So it doesn't necessarily need to be a provider that we have certified. We can access providers, throughout the community that the family might live in. And so, yes, we do, that does become sort of evidentiary, if you will, within our hearings and our testimony. It becomes discovery. So everything we collect during the course of our investigation or even our case is discoverable and is provided to all parties in the matter. And then we do rely on, witnesses, fact witnesses to come in and talk about that. We're social workers. We know we are not medical providers. We know we are not mental health providers. We can't make those type of diagnoses. So we do rely on the experts to help us form an opinion.
Okay, thank you very much.
Representative Love.
Thank you, Mr. Chair. Thank you for coming to testify and giving us all this information. A little personal history. 20 years ago, I was going through a divorce. My daughter
Quickly,
and
get
her-
to the question quickly.
So it's going to get, can I have a minute?
No. Not for a backstory, no. Other questions? Thank you. Thank you for your testimony.
Thank you, everyone.
And as announced previously, next I will go to State Representative per custom. And then after that, we will take other pink cards and everyone will have 4 minutes. Chair calls Representative Paige Beauchemin.
It's on. I wasn't sure. Thank you, everybody, for having me, for being here and for hearing me. My name is, let me get to my notes. My name is Representative Paige Beauchemin, and I represent Nashua's Ward 4. I first here want to express my gratitude for the folks responsible for this bill, for drafting it. Having had a career in maternal child health, and as a mother, I am in full support of strengthening our ability to protect children. I am here today, though, to speak to some concerns that I have about some of the language in the bill. And with the current language, I do oppose this bill. I've been a registered nurse for over 15 years and have spent that entire time working with moms, babies, and families in several capacities, inpatient, outpatient, health tech. I've worked significantly with moms suffering from maternal substance use and their infants, both prenatally and postpartum. I've cared for those babies that you were asking about, Representative Corzine, and I've seen both sides of that in my own care. My main area of expertise is actually maternal mental health, and I am certified in that through the only certifying organization in the country. There are several pieces of language that concern me here, and I will say with the amendment, it's been a little hard for me to know off the bat this morning what's still in there and what isn't. But given that there are several different pieces of it, it is something that I don't think is solved easily with a few word changes. And one of the reasons that I have that concern is that defining substance use in and of itself in any way as neglect or abuse is not how we would define it clinically. So we really need to separate the difference between having a mental health condition, which substance use is, and actual harm that it does to the child. So there are others who will speak to that in more depth, but what is widely accepted in the space of perinatal exposure is that fear of a referral to DCYF significantly decreases engagement in both recovery programs and prenatal care. And substance use is a clinical condition that should be addressed with protocols that are developed by clinical experts. It's really important for me to call out right now that per the CDC, perinatal mental health is the #1 cause of pregnancy-related deaths right now when taking into account suicide and overdose. And so from this perspective, let me go to my next page. What I'd like to emphasize is that while well-intended, we know that this bill is very likely to decrease maternal engagement in recovery programs as well as prenatal care. And thus the bill increases the risk for increased maternal deaths in New Hampshire. The reason is that regardless of what we know, we might have talked about, well, what will happen after they're referred to DCYF, and it might be great. The problem is that regardless of what we know, folks who are most vulnerable, who have been targeted before, and I think some of us know we support DCYF, and we know there's rooms for improvement. Folks who have been targeted are often from more vulnerable groups, including those with substance use concerns. And so those folks have a higher fear of the system. Regardless of what we know is going to happen, they have a fear. And I want to share just a quick little anecdote. This is a personal experience. It's an anecdote, but this scenario is completely backed up with evidence, as some other folks will attest to. I do trainings. I train folks in the clinical field how to deliver perinatal mental health screeners. So screeners that will help us find folks that have perinatal or maternal depression or anxiety. A few weeks ago, I was training somebody. Now, this person is a clinical person. She happens to be a single mom. She said to us, I personally would not take this or would answer incorrectly because of fear that if I fail it, which you can't fail a screener, but her words over and over, if I fail it, DCYF will take my kids. This is a healthcare provider in the space of helping moms and babies. And that is what we're dealing with. That perception is out there. And when word gets out that there are higher, that they'll get more attention for it, or that there could be more referrals, we're going to see fewer people accessing the care that they need. In summary, I do respectfully request that we vote ITL on this bill in the hopes that we can bring in additional clinical experts. I think that on this side, we didn't have enough of the maternal substance use input here. And I know there's a lot of us who would really like to help craft some of the wording so that would be in alignment with what we know to be best clinical practice for moms and babies. Thank you.
Representative, today
Yes.
is the hearing.
Yes.
And if you have additional experts or whatever's
They're here.
who are not here,
Oh, yes.
they can certainly speak with the prime sponsor if the prime sponsor is willing.
Wonderful.
Are you willing to take questions?
Absolutely.
But I don't see any.
Wow. Well,
Welcome to
either
the
I did a
House.
really bad job or I answered all the questions.
Welcome to the House of Representatives.
Thank you very much. Thank you, everybody.
Chair recognizes Jima Wilder. So I get Jima and I blow Wilder, really? How am I doing? Jima. I'm going to go with Wilder for the surname. And remember, we're on our 4-minute thingy here.
Good afternoon, representatives. My name is Jama Wilder, and I'm from Campton, New Hampshire. I oppose House Bill 553. My concern with this bill is the vague and ambiguous language that it would allow for unconstitutional abuse of power. I came here today not only for the protection of precious children, but for the generations to come. Adding in language such as emotional, mental, behavioral, and psychological needs and welfare allows for children and parents to come under attack without having a standard for measure. There are times when my children don't understand the importance of lessons such as sharing, serving, reading, math, history, caring for others, and sometimes proper hygiene. When a child becomes frustrated with these things, it's our job as parents to help them see the importance of it. I have worked with many children over the years and have had untold complaints about doing things that were hard for them, but helped them grow and learn necessary physical, mental, and spiritual lessons. Over the last 2 decades, the emotional, psychological, and mental well-being of children has rapidly been on the decline. There has been a rise in suicide and decline in mental health since doctors, schools, counselors, and other organizations have put so much focus on it. When are we going to consider some of these adults having conversations with children are causing more harm than good? exposing children to explicit questions about body image, sex, drugs, and suicide when they have never even considered it, plants seeds and causes harmful thoughts. When I brought one of my children to the doctors, they were given a survey, and many of the questions had to do with body image. After we left the doctors, we talked about the visit, and sadly, my child shared that they had never thought about their body image until the doctor asked. The seed was planted and grew. I spent years trying to make something that came from a survey claiming to help children. I'm sorry, I spent years trying to undo something that claimed from a survey claiming to help children. This bill is too broad and allows for family court to circumvent due process without proving guilt. It will also include many major costs and resources in a system that is already taxed. I ask that you reconsider this and think about what's really good for the children. Thank you.
Any questions for Ms. Wilder? Seeing none, thank you so much. And next time you come, I owe you 1 minute and 22 seconds.
Okay.
You're welcome.
Thank you. I tried to shorten it for you.
You did a great job. Chair recognizes Matthew Hassel. It's a double barrel first name, and I can't quite read the other half of it, but come on down and fill me in.
I thought this was for representatives right now.
You're going to have to sit down at the microphone so I can hear you.
I thought this was for representatives right now.
I'm sorry?
I thought this section was for representatives.
They have finished.
Okay. All right. So I'm in opposition of
And you
this
got
bill.
4 minutes, starting now.
ITL. I'm going to get right to the legal principles of the state action doctrine, which exactly. I'm going to get right to the legal principle of the state action doctrine, which is exactly what this bill is, state action. This state action doctrine is a legal principle that limits the application of constitutional rights to actions taken by the state or its agents. It protects the people from action taken by the government that violate their constitutional right. The doctrine applies to all levels of government, including federal, state, and local. It prevents the government from directly or indirectly depriving people of their constitutional right. It also prevents the state from becoming significantly involved in the actions of private individuals, making those actions the same as state actions. The doctrine is used to determine whether a claim based on the Constitution is valid. The first 3 words of the second sentence of the 14th Amendment are "no state shall." This sentence declares that the states may not abridge the privileges and immunities of the people of the United States or deprive people of life, liberty, or property without due process of law, nor deny to any of the people the equal protections of the law. As recently decided in the Supreme Court of the United States in Christopher L. Wilson versus Hawaii on December 9th of 2024, Americans need not engage in empty formalities before they can invoke their constitutional rights. As Wilson versus Hawaii states, we people do not have to engage in the empty formalities of the state before we invoke our constitutional rights. By enacting this bill as state standing law and procedure, the governing body and its agents will have failed to give the state and federal constitutions its due regards. When this happens, the government reduces such rights to a second class of protection and guarantees. These constitutional rights are not a second class of protections and guarantees subject to an entirely different body of rules than the other bills of rights. The state or its agents and agencies do not have the right to inflict wrongs upon the free people by denial of the full protections of the law, such as due process of law within the meaning of the 5th and 14th Amendment, equal protection under the law within the meaning of the 14th Amendment, and the 6th and 7th Amendment protection to a jury trial, which is what this bill prevents. Because all state officials, including yourselves, are by the Constitution to be required to be bound by oath or affirmation to support the Constitution. The 14th Amendment of the Constitution has vested in the Congress of the United States the power by proper legislation to prevent any state from depriving any of the people of the United States of the enjoyment of life, liberty, and property. The constitutions can, by law, provide against all such abuses and denials of rights by the state and by state actors or combinations of persons or corporations, such as those who enact this bill and those tasked with enforcing it for conspiracy, deprivation of rights under the color of law. This bill, as proposed, will warrant a finding of unconstitutional state action triggering the state action doctrine in a federal court. As of this day, I am litigating in the First Circuit Court of Appeals on an ongoing tort action against 3 state actors for violations to the Constitution and statutes just like this. That case is Hassel versus Kimbart, case number 24-1442. Depending on how that case is decided, will be further taking action to the United States Supreme Court, which is protected by the First Amendment to redress for grievances. This bill is opening the state and its agencies to further tort claims and unconstitutional state action if this bill is enacted, which, if passed as proposed, will be added to my case in the event the case goes to the United States Supreme Court. As mentioned above in Wilson versus Hawaii, we the people do not have to engage in the empty formalities of the state. Given the unconstitutionality of this bill, it is already self-defeated if enacted as proposed.
20 seconds to go.
As Article 1 of the New Hampshire Constitution state, all government of rights originates from the people, is founded in consent. As one of the people, I do not consent to this. I oppose this bill as proposed.
Are you saying that an agency of the state has no rights whatever to remove a child from a home?
To violate the constitutional rights of the state and the federal constitution, no, they do not. You have to give due process of law. You have to give equal protection on the law. This bill right here goes off the judge's discretion, and the judge denies over and over and over again the right to a jury trial.
Okay, thank you. Any other questions?
There's plenty more if you want the actual.
Yes, Representative Seidel.
Thank you, Mr. Chairman. Thank you. I'm just curious if you could send us a copy of your testimony.
Do I have like an email, or I can just hand you this and you can.
If you don't need it, that'd be great. Thank you.
Yes, ma'am. Any other questions?
Any other questions? Thank you. And the chair recognizes Leah Cushman from Ware.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Leah Cushman. I live in the town of Ware. I'm a former state representative, and I am on the board of Rebuild New Hampshire and part of an organization called Assembly of New Hampshire People called New Hampshire Family Justice. A lot of great points were made in the last testimony. And your question at the end, sir, just to tie it in and explain how this is unconstitutional a little bit further. SEC versus Jarchese. It was a court case where it was a civil action by the state, by the federal agency, the Securities and Exchange Commission, against a fellow named Jarchese for fraud. And the court found that if a suit is in the nature of an action at common law, then the matter presumptively concerns private rights, and an adjudication by an Article 3 or a common law court is mandatory. In essence, due process rights must be honored when the action is similar to an action that at the founding would have been guaranteed that due process. Family court treats abuse and neglect like civil cases when that makes it so that we're not being tough on crime. We're being lenient on crime because it takes hearing after hearing to get anything done. And in the meantime, the child stays with the parents, unless you have the ex parte, which is sometimes used, but it requires a lot more threshold of evidence. So DCYF is blaming the court. The courts blame DCYF and others, but DCYF screening and the process there is a big part of the problem. Every other crime, you have a complaint and then it's given by someone in a police report or an affidavit, then they have liability if it's wrong, if they knowingly gave false information, and then that gives them jurisdiction to move into investigatory phase or get a warrant for surveillance or search. So they can go in and obtain the evidence needed to get a child safe immediately, whereas DCYF relies with the Child Protection Act on voluntary cooperation in most cases. So it gives people time to hide a child, to move a child. And this only started back in the 80s. Prior to that, these were treated as crimes with the full investigatory power of law enforcement and the protections of due process in a criminal court, which is very specific. So the soft on crime approach is letting kids fall through the cracks because they don't meet the screening threshold, and DCYF basically can make arbitrary decisions to not follow up, or if they don't make contact with the parent, they don't follow up. We saw that happen with Harmony Montgomery. So to say that you're going to use this process before you go to a criminal procedure, it's backwards. If this bill cited simply that abuse was defined as a conviction of
20 seconds
of one of the criminal statutes concerning abuse, endangerment of the welfare of a child, sexual assault, battery, domestic violence, and required that before proceeding, that would be fine, because that would be how it used to be up until the mid 20th century. There was criminal and civil, and then there was equity.
Time's up. Any questions for former Representative Cushman? Yes, Representative. Yeah.
Thank you, Mr. Chairman, and thank you for being here. My question is, are you saying that you believe that within DCYF, parents are giving way too many chances to hurt their child?
I'm saying that we're not following a consistent process there. There's a lot of room for arbitrary decision making, and they are not trained law enforcement. And from time immemorial, the common law and criminal procedure in the United States since its inception has provided consistent guardrails for how crimes are investigated and pursued. And because they are treated differently and there's a lot of wiggle room for discretion, that yes, sometimes it goes in the favor of someone who's hiding abuse of a child, and sometimes it goes in the favor of DCYF agents who are a little too zealous and have maybe their own personal biases and are investigating, more zealously or, targeting someone based on their own perceptions.
Follow up?
Oh, sorry.
Oh.
Thank you.
Okay. Anyone else? Thank you for coming. Chair recognizes Liz Glenn. We have all these fascinating names that I'm butchering. They're wonderful names. You'll need to turn
What I've just handed out is a petition to redress, list the constitutional things that they were referring to, saying that the DCYF is a creature of the legislature and operating under legislature and not under constitutional rights, and therefore violating constitutional right, fundamental rights of parents. My name is, like I said, my name is Griselli. I am a parent. My children are currently in DCYF custody. They were removed from me because I was homeless. I'm going to, and I just wanted to validate and verify. I just want to affirm that everything that I testify to up here that I can prove. I have proof and evidence to back up what I say. So I'm just going to read the ex parte that was filed that was the cause of removal of my children. Yeah. Okay. On September 15, 2023, the division received a call from Heather Moran with Manchester City Welfare stating Ms. Glenn was not eligible for services due to monies that were unaccounted for and was placed on a 14-day suspension. Ms. Glenn was refusing to leave Manchester City Welfare and was stating that she was going to camp on the lawn outside of City Welfare with her 2 children. Supervisor Megan Bellavant spoke with Ms. Glenn, who was unable to identify a place for her and her children to stay. Due to Ms. Glenn being disorderly at City Welfare, the Manchester Police Department was contacted. Manchester Police was able to arrange shelter for Ms. Glenn through Families in Transition through the weekend. Today, September 18th, 2023, Ms. Glenn returned to Manchester City Welfare, but was informed that she was still not eligible for shelter, nor that FIT had any open beds for her and her children. Manchester Police Department was contacted again in Manchester City Welfare due to Ms. Glenn's escalating behavior, and Ms. Glenn was arrested for resisting arrest and disorderly conduct. CPSW Elizabeth Barney was able to speak with Ms. Glenn prior to her arrest, and Ms. Glenn was again unable to identify a place for her and her children to stay, thus leaving the children without appropriate shelter for the evening. Based on the foregoing, there is reasonable cause to believe that the children are in circumstances or surroundings that present an imminent risk to his or her life that necessitate immediate out-of-home placement. The children are without proper parental care or control or other care or control necessary for the physical, mental, or emotional health, and their health is very likely to suffer serious impairment. Based on the foregoing, there is reasonable cause to believe that the continuation in the home is contrary to the welfare of the above referenced children. Given the circumstances, ex parte relief is the only relief available for the division. I heard a lot of people say up here that their main thing is to keep the children in the home, and that's the first thing that they do. But what this ex parte fails to say is that my children were with my older son. I have two older children. One's 24 and one's 29. And my children were with my oldest, one of my oldest children. DCYF do not... DCYF, my experience, I had my parental rights terminated 16 years ago to my 3 middle children because I didn't have suitable housing. So here I am again, I don't have suitable housing, and you remove my children, even though that doesn't constitute neglect. Although the judge signed off on this just because I didn't inform them of where I would be staying with my children, as if that's any of their business. DCYF has enough power, and that they abuse right now as it is, for us to add on all this extra language to this bill to give them more power to you to abuse. Because as it is right now, they don't follow their protocols and they don't follow this law. Because this ex parte should have never been filed, number one.
15 seconds.
Number two, and I object to that 4 minutes because the stakeholders that really don't have anything at stake up here, but we heard quite a bit from them. So I would like my time as long as it takes for me to speak.
Okay, this petition for redress, where do you expect to send this? Who's going to receive it and consider it? Turn your mic back on.
This is for all of you who are on this committee to redress the issues with DCYF. And this bill is not going to help to do that.
And you're saying that DCYF has, I'm reading it now, no authority to interfere with the liberty interest of the people.
Correct. They are a legislature creature that are running under legislative laws, which are not constitutional. Fundamental Constitution of New Hampshire, which I wrote the articles on there, that are corresponding to the Constitution, to the fundamental rights that we are being denied on a daily basis.
Okay, I got it. Thank you. Any questions from the committee? Okay, seeing none. Thank you.
As I said, I think it's unfair that you gave everybody who doesn't have anything at stake here.
The chair now recognizes.
That you gave everybody here who doesn't have anything at stake, and my children are at stake, and you don't let me speak for more than 4 minutes.
That is correct.
Put you in those chairs, by the way.
My next call is to security. The chair now recognizes Farah Sheehan.
Turn on your mic.
I will submit this online, but I have a few copies.
You can actually sit down. Oh, you're going to go do that. Okay.
Good afternoon, committee members. Thanks for having me. My name's Farah Sheehan. I'm a I'm a resident of Amherst, New Hampshire. Not a representative yet, but maybe I'll do that someday. So my written testimony is much longer than what I'll share here, but I wanted to make sure that you had, more of the details and some resources and my qualifications for why I can share what I can share. So I strongly agree that changes are needed to 169C. I'm a registered nurse. I'm a master's prepared registered nurse. I've been in the field for 30 years caring in the maternal child health realm, especially with families affected by substance use disorder and trauma. So I know we need changes, but I oppose the bill as written now, and I believe that changes as written in this bill will contribute to the harm of children and families in New Hampshire. Mostly what I do right now is I work with maternal child health teams and state quality improvement groups across the country, and specifically Representative Corzine work with those families who are dealing with the complexities of substance use in utero and then the consequences of that for themselves and their infants. There's a model of care called Eat, Sleep, Console that New Hampshire was actually the first state in the nation to implement this model of care in all of our, at the time, 16 birth hospitals. And I was a leader in that initiative and that education. There's now been research done on the Eat, Sleep, Console model of care funded by the NIH, by the National Institute of Health. And basically every state in the nation is saying, please come help us, come help our teams implement this model of care. And it specifically addresses, your concerns. So I can speak to that at the end if I have time. The language in the bill that's the most concerning to me that I want to speak to is the presumption of harm as related to substance use. So I'm not going to read it because it's there and you can read that, but this is really not a trauma-informed section of the bill. It's not trauma-informed language. It's not a trauma-informed approach. And it's not a trauma-informed way to protect families and children. So I'm going to say something that might sound contrary to everything you've believed in your entire life, but it is the truth when it comes to science and research. Substance use by a parent does not equate to child harm. It doesn't. A parent who has a chronic medical condition in any other way, like diabetes, maternal obesity, and even other risk factors like poverty or homelessness, as we just heard, doesn't equate to child abuse and neglect. Is it a risk factor? You bet. Is it one of the most important risk factors that our society needs to deal with? You bet. Does it actually equate to child abuse and neglect? No. So one example of this is the American Academy of Breastfeeding Medicine, which is our gold standard on who should be getting mother's milk, how to get mother's milk, what should we do for encouragement and restrictions and all that. That organization says if a mother is nursing her child and she's struggling with substance use or she's using substances, this is not a reason to not breastfeed. Let me say that again. If a parent is using substances and they're breastfeeding, the highest level of organization in our society who looks at breastfeeding and makes determinations with all of the experts across the country does not equate it to child abuse and neglect. They do not say you can't breastfeed. They say, how do we help you mitigate the harm? How do we help you get support? How do we assure that your child's outcome is as best as it can be given the situation of your health, your chronic disease, and your family? That might mean a mother is continuing to use THC and breastfeeding. This is what is actually happening in healthcare because that's the science behind the best practice.
20 seconds.
So we need to really look at this bill and make some changes. We do, but we absolutely have to make sure that we're taking out the stigmatization and the discrimination around substance use. We would never say presumption of harm based on poverty, lack of housing, maternal diabetes. We would never say presumption of harm based on parental trauma because that's one of the risk factors. So we should not exclude or specifically pull in one group of people because a certain moral code has existed in our country.
How about fetal alcohol syndrome? Got to put it back.
Put it back on, sorry. Yeah, so that's a complex issue, right? Like there are situations when children have long-term consequences. However, it is proven that not all substance use leads to long-term developmental outcomes and harm. In fact, neonatal opioid withdrawal syndrome is often a temporary condition not a long-term chronic disease that a child experiences as a result of maternal substance use. It's temporary. And how do we deal with that? Is we make sure the baby is with the mother and has cuddling and has breast milk and is in a low stimulated environment, and lots of other ways to deal with the temporary medical condition. It's not a long-term consequence in all cases. So in some cases it is. And that's what we really need to be looking at, is what is the actual harm to the child. It's not the substance use itself.
Representative Rice.
Thank you, Mr. Chairman. Thank you for your testimony, and thanks for taking my question. So I have to ask you, because I think everybody here at this table has heard the stories of children who have gotten to their parents' drugs and are dead. Death is long-term. So how do you propose then that we protect these children from that without this language being in this bill?
Just like we do with any other child who could be at risk for anything, right? So I have family members who use farm equipment and machinery. They need to make sure that their children don't get into that and get hurt. If they're not protecting their children from the situation that they're in their home, then that's unsafe. But that could be across the board. That could be for someone who's taking prescription medication for their mental health care. We can't say, oh, you have a mental health condition and there's drugs in your home to take care of you, therefore we're gonna, a presumption of harm and make sure that your child, is involved with DCYF. We say, what is the actual behavior that's putting the child at risk, not the condition or the disease or the things we're using to help the person, be well.
Follow up.
Thank you, Mr. Chairman. So I can't wrap my head around this.
I understand.
Not because I have heard stories of children who are dead because they got into their parents' fentanyl. Your mental health medication comes with a child-proof lid. Okay? Fentanyl you're buying off the street does not. And I just really feel that makes no sense to me, because we're going to end up with a lot more dead children, and I can't be a part of that.
Can I respond?
Yes.
You'll see in the written testimony, I didn't have time to talk about, excuse me, that one of the problems is that engagement, as Paige discussed, engagement with the system when families are struggling. And so my belief, and actually what evidence shows, is that when families actually can engage and they're not afraid, then it leads to better outcomes for children, less deaths and less maternal mortality and morbidity. So it's actually, I know that it's hard to wrap your head around, because this is something that we have all been born into in our culture, that substance use means bad person. Substance use means I'm going to be unsafe, and it actually doesn't. Sometimes it does. Sometimes having a farm is unsafe. Sometimes being homeless is unsafe, but not across the board. We can't just blanket it as one group of people. It's discriminatory, and it's actually not accurate. I mean, that'd be great, but the reality is.
DeSimone.
Thank you, Mr. Chair. Thank you for taking my question. You said you were a nurse, correct?
Yeah, I am.
Follow up.
And you talked a little bit about the nursing mother who may be involved or addicted to drugs, correct?
Yes.
Follow up?
Follow up.
So failure to thrive is a very important condition for an infant and can cause lifelong effects. Is that correct?
It is.
Thank
Follow
you.
up. Okay.
So in the case of a mother who is a cocaine addict, comes into an emergency room, the baby has failure to thrive because the baby can't suckle, because in the milk is cocaine. Would you say that would be a detrimental effect of the drug addict mother?
First of all, failure to thrive is a very complex condition that is usually multifactorial. And so when there's a situation where there's a parent using substances and that's affecting their overall ability to be able to care for their child, then does an intervention need to happen? Yes. I'm not saying that that shouldn't happen.
Thank you.
I'm saying that blanket substance use as presumption of harm should not be part of our code, our statute.
Thank you for your testimony.
You're welcome.
Anybody else? Yes, Representative Georges.
Thank you, Chairman. Thank you for
You're welcome.
your testimony. I just in case, like you said about the addiction and drug or alcohol, like as a representative Rice ask you for protection, I would like you to know how really you can protect a child. I want to really know because I didn't.
How can we protect a child in a situation where parents are using substances in an unsafe way? Is that your question to me?
Yeah.
Well, it's we need lots and lots of ways to do that. We need resources for housing so that parents aren't unhoused. We need more funds for mental health care and substance use. You know what we need in New Hampshire? We need a residential treatment center where moms and babies can be cared for together and not separated. We need foster homes that are willing to take in mothers and infants together. We need trauma-informed, educated workforce across social, medical, and educational services and systems. I mean, I could go on. I could probably write a book, and maybe I will, but there's lots of things that we need. But to stigmatize one group of people and call them out in this legislation and in the existing 169C that we already have is wrong, and it's not safe.
Any other questions? Seeing none, thank you for your testimony.
Thank you for listening.
Chair recognizes Randall Collier. Randall Collier?
Good afternoon, Representative, Chair and Representatives. Kind of against this bill. There's been a lot of fallacies spoken here today. Title 42 is a public health and welfare. It's a non-positive law title. It seems like these agencies, the executive branch state agencies, they're obviously not following due process. And if these statutes are actually going into circuit court, and before someone was talking about preponderance of the evidence and difference between criminal statutes and civil sanctions and whatever. So if we're talking about civil, the Fourth Amendment of the Constitution says probable cause can't come from civil disputes. So Judge Gardner was in here and he said that rules of evidence don't apply what they want to be as a gatekeeper for reliable information. Judge Gardner wrote on my order that rules of evidence do not apply and the rules of evidence do not apply to the orders I seek to vacate. So criminal statutes in family court without evidence, and he denied the motion to vacate the protective order.
Sir, we're going to ask you to address the bill.
I
This
am.
sounds like you're addressing a law case.
I'm addressing the unconstitutional actions of these statutes in circuit court where evidence doesn't apply, which means it's not a fair court. And it has.
Does apply. The rules of evidence are different. I've read that book several times.
All right, well.
You may continue, and I'm not penalizing you for my speaking. Go ahead.
What do you have that says rules of evidence do apply? Because I have it in writing from the executive administrator Gardner that rules of evidence do not apply. So let's time out and try and figure this out, because now we have a contrast. And any ambiguity in any law always favors the defendant. So I got a lot more to say, but the circuit courts, administrative law courts can't hear constitutional claims. That's why they take our kids away. Kidnapping, peonage, stalking, extortion, you name it, that's what they do. So I'm against this bill because nothing in it is going to change. I like the constitutionality of it, but it's an unconstitutional court. So just having constitutional verbiage in the statute doesn't make it constitutional. So I haven't seen my kid in 6 hours and 12 years because of New Hampshire Family Court, Michael Gardner. So
We do not mention names, sir.
Well, he's retired, so.
We do not mention names.
So you're saying that rules of evidence do apply, and I have it in writing that they don't. So
I did not say that. Continue.
you did say that.
If I did,
Can I have a recording from the record? Anybody?
no, you may not.
Yeah.
Then let me clarify. The rules of evidence apply in the discretion of the judge.
Well, no, that's illegal. You can't do that. You don't have discretion on the evidence. Either the evidence is there, and if it is there of a crime, then you get transferred to a superior court for a constitutional
Okay,
referral.
you've got 30 seconds left to tell us why we shouldn't vote on this bill.
Because it's unconstitutional.
Okay. Any questions? This committee will eventually vote on this bill based on this bill. And any questions of the constitutionality is not our place to decide. I believe it has been decided. It perhaps will be redecided, but that's not what we're doing here today. When we exec, we will exec on this bill if we think it's a good bill or a bad bill. The presumption is this bill may be put forward. Others, it is their job to rule whether this is constitutional or not. That's not us. Chair recognizes Courtney Tanner from Dartmouth Health. I'm just wondering if you've had a chance to read the amendment.
I have.
You have?
Review. I review.
Okay.
Yes.
Review it. Fine.
Thank you. Hi, for the record, Courtney Tanner. I'm the Senior Director of Government Relations at Dartmouth Health. You guys have complicated and heavy topics in this committee. And I'm coming to you today with more complications. So want to thank you all for your thoughtful consideration. Dartmouth Health is home to a number of programs that I'm proud to represent, a couple of which are the Northern New England Perinatal Quality Improvement Network. We also are home to the state's only child advocacy protection program, and we actually have partner organizations across the state, one of which was mentioned here today. We have a partner program at a hospital in Manchester, and it sounds like that provider was maybe involved in the drafting of this, but for the record, Dartmouth Health was not involved in the drafting of this bill. We do have some concerns as an institution with the bill, particularly around, I'm looking at the amendment now on the first page, lines 27. There is a reference to being born alcohol or substance exposed. And so have some concerns around how that's implemented, how that's defined, that you've heard testimony today about how there are clinical best practices around children who have been exposed to substances in utero. I don't want to repeat that testimony for the committee, but just want to underscore some of the testimony that you've heard from a nurse just 2 testifiers ago. So I want to underscore that we are deeply committed to the safety of infants that are born in the state, to children, but do have some concerns about the amendment as drafted. We would be happy to work with the committee on the amendment, but we do have some concerns. I also have written testimony that I will send to the committee. It's in a PDF form, and I will email it to you from one of our providers. I'm happy to take questions. I'm not a practicing clinician, not a clinician at all, but happy to take questions and make myself available to the committee.
This amendment has not been formally introduced because we are not in an exec session. The chair made a ruling that since this is what we will probably consider, we should consider it now and not fight over stuff that probably won't ever appear in an exec session. If the prime sponsor wishes at some point to consult with anybody, everybody, or nobody, that is your prerogative. So that if the amendment, when we have an exec session, is exactly this amendment, that is your privilege. If it is changed, that is your privilege as well. And Representative George, would you pass down the blank pink card, because people are now using stray pieces of, no, to me. Thank you. Because people are using stray pieces of cardboard, which is very creative, I think. I know. So if that's what's that? Oh, that's somebody. That's an old card. Does anybody have a blank pink card up their sleeve? Okay, Chair will take this one. Oh, you do? Of course you do. Well, all right. Could you fix this? Thank you. Anyway, keep those cards and letters coming. Anyway, it is up to Representative Gregg as the prime sponsor. You may bring in an amendment on exec day in whatever form you wish, in consultation with any folks here, not here, or wish they were here, or not, as you choose. So that's how working with the committee will take place. Okay? Any questions? Oh, after that, I was hoping there'd be. No? Okay. Thank you. Former Representative Betty Gay of Salem, come on down. And she says she wants to speak for 4 minutes. That's what I want to.
Okay. I've passed out a blue sheet.
Oh, blue sheet. Okay, you're not on the clock just yet. Blue sheet, blue.
It has references. It
I've
has
seen
references on it.
Where? This blue? This color blue? Okay, good, thank you. Okay, let's take the blue sheet out.
With the dirty printer that I could not clean.
Let's look at the blue sheet, follow the blue sheet, because former Representative Gay's 4 minutes is about to start now.
Okay, the co-sponsors and sponsors of this bill read like the who's who of people who are concerned for kids, and I feel like one of them. I have a criticism of this bill that I wish could be built into it. I don't want to trash the bill. I just want it fixed. ACEs were mentioned, adverse childhood experiences. Those are critical. If somebody has 4 of the 10, the chances are they will lose 12 years of their life. So we're talking about really serious things. I'm curious about what's the difference between psychological versus emotional abuse. To me, they sound like the same. It sounds like kind of overkill. Immediate intervention, removing children, requires immediate investigation to verify or clear a parent. One of the reasons that the family court has such a bad reputation around this world is for the errors that are made. They either don't remove children or they remove children who shouldn't be removed. And speed is of the essence. So whatever, if you're going to do an ex parte because you think a child's in danger, you not only need to remove the child quickly, but you need to investigate quickly, because we are aware of many people using it as ammunition against a parent they're trying to get even with. So then they know that that child's going to be removed, probably to them, for an extended period of time while this investigation slowly takes part. That is cruel. There has to be a review. This is my opinion. This is what I want to see put into the bill. There must be a review of the judicial court order by a review board who are not part of the court. The only review we have right now is the JCC Judicial Conduct Committee. They are staffed by attorneys and court employees. It's no wonder that they almost never find a finding.
Well,
the review board needs to be created consistently of child psychologists, pediatricians, adult psychologists, people who are not part of that investigation, but they have the expertise that can evaluate the family. One of the other bills that people are asking for is that whenever a child is going to be evaluated, are be treated, they be evaluated first to see if there really is an issue there, that the child needs counseling or the family needs counseling. Let's start with knowledge. And the last thing is the very name description of the bill, triggering a rebuttable presumption of harm in abuse and neglect. Rebuttable presumption of harm is the opposite. It presumes that you are guilty and you have to prove that you're innocent. So it's backwards to start.
Any questions for not only former Representative Gay, but alumna of this committee? Am I correct?
Well, no, I always wanted to be on this
You always
committee.
wanted to be.
And you wanted to be on this committee. Only then I didn't get elected and you got put on this committee.
Life is cruel. I got that. Anybody? I've mentioned this before. I don't think I've mentioned it to you. We made some beginning progress in the Special Committee on the Family Division of Circuit Court. Basically, we picked low-hanging fruit, and I think we did some good work. I asked the Speaker if we could come back and try a couple more years because of the trust level. We did not come at them adversarially. We came at them collaboratively to gang up together to fix problems. And they worked very well with us. But now maybe with that trust level, we could go a little bit higher up the tree to some of these other issues. I asked the Speaker, therefore, would he reconstitute that committee? And he said no. But what he said was, Mr. Chairman, you can form a subcommittee out of this committee and continue the work. So I probably will. And I'm suggesting that what you said, if you could put that in a memo to me about where you see one of the problems. Now, solutions are not obvious necessarily. Some people were accusing judges of knocking off work at 4 in the afternoon. What that meant was that was the last case they heard. You know my wife. The last person she sees as the doctor is at 4 in the afternoon. She gets home at 7:45. The problem is not the judges in this case. The problem is there's not nearly enough of them. So things have to be put out because there's a whole bunch of other people needing to have a court case before we can get around to you again. We need more judges, and this may not be the time to do it. That is one aspect of this. Your point about a review panel on judicial orders, that may be something we would want to consider, but could you put it up in about 5 paragraphs and send that to me? Because I'm collecting possible topics for our next round as we work with family court.
Thank you. And may I make the suggestion that crafting bills that affect the court could also use their input. So rather than just counting on their acquiescence and liking your ideas, that it actually gets put into writing, into bills, instead of just practice.
You may be excited to know that some of us are doing just that. Perhaps we could do that some more, but certainly for some of us who have relationships with justices, we've run things by them. I'm testifying on a bill tomorrow that has spent a lot of time with the administration of Circuit Court so that it's something that could work. But thank you for the suggestion anyway. Anybody else? Last call.
Did I use up every second because I wanted to say what this is? It
You
wasn't
have
what I said.
precisely 22 seconds to tell me what this is.
Okay, this is several different sources for information because people like to say, oh, the courts favor women or the courts favor men. Family court has a bad reputation around the world, especially in all the English-speaking countries. So they have good ideas, but this shows you that really things need to get fixed, and it's not just slanted, not just for women or not just for men.
Thank you, and you owe me 14 seconds next time.
Okay. And I'll email this to you so you can click
I
on.
appreciate that, and that goes to anybody else on the committee. If you've got some thoughts about what are some things that Circuit Court could be improved in, you know, their constant word to us during this process is, hey, we want to make things better, right? You heard that. So if you've got some topics, again, brief, the lawyers call it brief, but they're not. You be brief in both senses of the word, please, okay? Anybody else? No. So we are on 5:53. This adjourns the hearing on 5:53, and we'll exec it one of these weeks. Thank you all. What's the matter? You did? Oh, you know what? People were coloring on it. Come on up. We're back in again. Oh, I'm sorry. We thought this was left over from last time. Thank you for jumping up like that.
My apologies. I will be so brief because I know I'm now standing
So you were
between you and
looking
freedom.
for a new future with us.
Yes.
Thank you.
Hi, for the record, Emma Savini, Children's Behavioral Health Policy Coordinator at New Futures. We are a nonpartisan, nonprofit health advocacy organization dedicated to supporting all Granite State children and families. We are here in opposition to the bill as written. Specifically, I just want to call out a provision that's been cited already under the neglect statute or neglect definition, section E on the amendment. It's lines 27 through 29. We've already touched on it. We have the same concerns that have been brought up, that this may have a chilling effect on pregnant parents seeking treatment, both for substance use disorder and for prenatal care and subsequently perinatal care. We would suggest removal of this provision, in which case we would, I think, have no position on the bill, and would look to maybe additional improvements that could be made. But
little tweaking.
Yes.
Yeah.
But that is the main concern we have with the bill. Happy to take questions.
Seeing none. Thank you for jumping up like that.
Sorry.
We are learning pink card passing skills today, aren't we? Well, no, no, I don't mean you. I mean others. Okay. Thank you.
Thanks.
You haven't had your turn yet. This adjourns the hearing on 5:53. Thank you all.